All rise. Superior Court of Fulton County is now in session. The Honorable Judge Cotton McAfee's presiding court will now come to order.
Good morning. Please be seated. Morning, Judge.
Good morning.
All right, welcome back, everybody. Are we on the record? Fantastic. So we've got a lot of ground to cover today. And because of that, and because I think everything seems to be pretty well and extensively briefed, I'm going to attempt to try out some time limits this time around. So let's, if there's anything we need to address preliminarily, if not, I was thinking the one we could kick it off with would be the joinder motion, failure to join. We could start with that one. Maybe from there, move into personal jurisdiction, and then take up kind of the meatier issue of the motion to dismiss. And then seeing where we are on time, I think we still had outstanding from our last gathering, the defendant's motion to dismiss the injunction. Any other ground?
Yes, sure. One preliminary housekeeping thing. I believe we need the Zoom link. I believe Mr. McMurtry's attorneys also need it. Thank you so much.
Okay, that shouldn't be a problem. Should be emailing that over now. So do we want to hold tight before diving in? Wait for everyone to get that. All right.
Your Honor, good morning.
Good morning, sir.
I'm Patrick Townsend on behalf of McMurtry defendants. I was just going to say, I only need the Zoom link for the PowerPoint that I want to use. So we don't need to wait.
Same with us, Your Honor.
Yes.
That's all we needed. And for this little preliminary motion, we don't have it.
All right, fantastic. Well, let's kick it off then. Why don't we start and we'll say goal of 10 minutes for each side. And on the joiner motion, is that going to be Mr. Reyes or Mr. Wood?
I'll do it, sir.
All right, your motion, you have the floor, sir.
Thank you, Judge. Good morning, all again. On behalf of Mr. Wood, we file a motion to dismiss the plaintiff's verified complaint for their failure to join indispensable parties, or in the alternative, a motion to join persons needed for the just adjudication of the matter. We did that under OCGA 911-7, 911-12B7, and 911-19. A brief history. While defendants, Mr. Wood and his firm, complied with all the terms of a settlement and release that the parties entered into on March 17, 2020. The reason why this lawsuit was brought was a breach of that, an alleged breach of that agreement.
Well, Mr. Reyes, let me jump in here. I've gotten the history in every single filing. I think I know the background. Let's jump right into it.
Let's jump into
why do these two or why do these extra defendants need to be joined in here? Why are they necessary? Why are they indispensable?
Plaintiff's allegations are that Mr. Wood conspired with his lawyers at Alston and Byrd to deceive plaintiffs. And in doing so, he also conspired with Todd McMurtry and his law firm in Kentucky, and naturally the client, Nicholas Sandman, who refused to consent to their fees at the time when he was an adult. So for the plaintiffs to allege fraud against Mr. Wood and try to leave out the people that allegedly committed the fraud with him leaves parties out. And those parties are his counsel, Burby and Marquardt from Alston and Byrd. It would include Todd McMurtry and his firm in Kentucky, and definitely would include Nicholas Sandman, the client who ultimately decided I cannot consent to their fees unless they show me their billing.
So your contention is that the parties that are missing here are the Alston and Byrd attorneys as well as the client?
Yes, sir.
And would the theory of recovery here be ultimately, if they're to prevail on a fraud theory, that if they're all joint tortfeasors?
Yes, sir.
So if they just obtained a judgment against just one of the clients, wouldn't they be able to obtain their entire judgment and recovery just from one client?
Well, if they want to explore the fraud, these people would be part of the fraud. So they need to be brought into the case, irrespective of damages. at the liability stage of the case, they're needed. We cannot decipher the fraud and then move into damages if we still have not ascertained the liability. And to ascertain the liability, we need these defendants here.
So, and you referenced the an interrogatory question. What else do you have to point to that you think makes these folks part of the conspiracy or the fraud?
Well, there was no conspiracy or fraud to begin with.
Or from the plaintiff's
But if their
allegations?
allegation is that there was, they would certainly need to include Nicholas Sandman, and I can introduce his affidavit.
I'm familiar with it.
Okay. He clearly says in his affidavit that Mr. Wood did ask him to consent to the fee distribution. He also says that Mr. Wood never tried to convince him otherwise. He also says that he had no contact with Mr. Wood again, ever.
So could their theory of the case then be that Sandman had nothing to do with it? He was just an unknowing pawn in the conspiracy. Could that be a theory of the case?
It's not the theory of the case because Nicholas Sandman is the one who turns 18, is offered a settlement agreement to sign, is instructed that he can sign it, that he can consent to it, and he doesn't. Why not? We need to know that from Sandman, not from Wood, we need to know that from Mr. Sandman. Because it had nothing to do with Mr. Wood. Mr. Wood stopped being a part of this process on March 17, 2020. What happens immediately after is the COVID-19 lockdown. So instead of, when they enter into the settlement agreement, it was imminent that within days, this settlement would reach a probate court in Kentucky. A judge would approve or reduce the fees, and done. They would have been paid. But instead, what happened is that the courts were locked down for months. By the time that they reopened, Todd McMurtry had reached a deal with CNN, with whom they had settled. And the deal was that CNN would not pay the settlement funds until July, which is when Mr. Sandman had already become an adult. So they would forgo the probate court. That had nothing to do with Mr. Wood. So that's something that McMurtry and Sandman can talk about, not us. So yeah,
No, why do they have to be parties though? Couldn't you just as easily have them as witnesses and go depose them and find out these things you're curious about?
Oh, Mr. Wood? No, they would be parties. If it is true, and it's not, that Mr. Wood committed fraud, he couldn't have done it alone. He would have had to have done it with them. You cannot commit fraud alone. You need other people in this scenario to commit the fraud. Mr. Wood alone doesn't do it. Mr. Wood is the one that tells McMurtry's client, hey, he should consent. We already settled this case, we're done. Why they didn't, that's up to them, but that's not an issue of witnesses, that's an issue of parties.
Okay. And then I'm also kind of curious as well. I want to make sure I'm clear on what is it that I'm supposed to consider and when deciding what's a necessary or an indispensable party. Do you look at anything other than the complaint? And if so, do you have some case law on that? Or anything like that?
Yes, sir.
Saying that I'm supposed to go beyond the complaint.
Yes, sir. The general rule is that all persons interested in the litigation should be parties. Perkins versus First National Bank of Atlanta, 221 Georgia 82, at page 97. And as the court in Artson LLC, ARTSON, versus Hudson, 322 Georgia, app 859 at page 863 states, OCGA 911-19A mandates joinder of persons where complete relief cannot be afforded among those who are already parties. That's our case here. When the presence of parties other than those to the original action is required for the granting of complete relief In the determination of counterclaims, the court shall order them to be brought in as defendants as provided in this chapter, if jurisdiction of them can be obtained. And Gardner v. Gardner, 276 Georgia 189 at page 190. The concept of complete relief as set forth in OCGA 91113 and 91119A1 embraces the desirability of avoiding repetitive lawsuits on essentially the same facts or subject matter, as well as the desirability of joining those in whose absence there might be grant of hollow or partial relief of the parties before the courts. So in the instant case, complete relief cannot be afforded among those who are already parties in this case, unless we bring in Joe Burby, Chris Marquardt, and Olson and Burt LLP, and Nicholas Sandman and his attorney Todd McMurtry, who's already been brought in. Because it's important to know who decided that the division of fees as agreed to by the plaintiffs and defendants in their settlement release was not approved unless and until the client received plaintiff's time records. And he, not defendants, would, or his law firm, review and approve same. Sandman is critical. It is Sandman who needs to say what he did and why he did it.
All right, any last points, Mr. Reyes?
Well, I will rely on the brief that cites other cases unless the court wants me to go through them. I can do that for a few more minutes.
If it's already in the brief, then I
It's
think
in the
we've got it
brief.
covered.
Yeah, we have additional cases. We have I'm sorry.
What was your attention?
Sorry, Judge, 1 second. Yes. One last argument, Your Honor, on this issue. OCGA 91119, which governs the joinder of necessary parties, provides that persons subject to serve as a process shall be joined if complete relief cannot be afforded in their absence, or they have an interest relating to the subject matter of the action such that disposition in their absence may impair their ability to protect that interest, or may subject any parties of the action to a substantial risk of incurring multiple or inconsistent obligations by reason of such interest. And that's Artson LLC versus Hudson. And again, the elements of fraud against Mr. Wood cannot be predicated on Mr. Wood acting alone when you have all these other parties. They've already admitted that Mr. McMurtry belongs in the case. Well, if McMurtry belongs in the case, so does the client. And if Mr. Wood belongs in the case, and it is his lawyers who were in contact with these plaintiffs and their lawyer, then Alston and Burt would have been the one communicating the alleged fraud, not Mr. Wood. So they're indispensable parties as well. Thank you.
All right, thank you, sir. Mr. Beal.
Your Honor, real briefly. We understand that Mr. Reyes is a lawyer from Florida and may not be familiar with Georgia law. Georgia
All
law
right, Mr.
does
Beal.
not support this motion at all under any circumstances. First of all, the OCGA 91119A, which they have cited, explains the whole issue to us. There are two essential tests for determining whether a party is necessary to an action. First, can relief be afforded the plaintiff without the presence of the other party? Here, yes. As the court pointed out, they're joint tortfeasors. And under the law in Georgia, we can seek recovery from anyone. And second, can the case be decided on its merits without prejudicing the rights of the other party? Well, of course it can. In Hall versus Oliver, the Court of Appeals decision at 251, Appeals Reporter 122 says, and I'm quoting from it, the second question is not whether relief has been requested against the other party, but whether the other party has or claims an interest relating to the subject of the action and is so situated that the disposition of the action in her absence may, as a practical matter, impair or impede her ability to protect that interest. Joey and Chris don't have an interest in this case. They're essentially arguing that the only way to protect this imaginary interest is sue Joey and Chris. I don't think they want to be sued. They don't have a claim to any of this money. Nicholas Salmon doesn't have a claim to any of this money. He said, I'll pay X percentage of the fees as lawyer, of whatever I recover as lawyer fees. He did. We contend he fraudulently took it. That doesn't involve Nicholas Salmon. He's not going to pay us a dime over and above what he's already paid. He's not an indispensable party. Where several persons conspire to defraud another, one or all of the wrongdoers may be sued. And proof of the conspiracy renders the act of one in deceiving and defrauding the injured party the act of all. And this is Wilson versus Appalachian Oak Flooring at 220 Supreme Court Reporter 599 at page 609. As stated on page 7 of our brief in response. Additionally, when a plaintiff has a right of election as to which defendants to proceed against, OCGA 911-19 does not apply. An additional cite there on page 7. It is clear that the law, the statute, says this doesn't apply because these people don't have an interest in the recovery. Alston and Bird isn't going to get an interest in my client's fees, so they don't need to be protected. Secondly, the Georgia case law that interprets it makes it abundantly clear. Wrapping up, this is really nothing more than a desperate attempt to get somebody else to pay for Mr. Wood's wrongs. There's no theory that they have to be in this case, that Sandman had to be part of a conspiracy. He could have been, as the court said, an unknowing pawn to Mr. Wood's fraud. There is no basis. And the plaintiff has, or the defendant, the movement, has the duty to show some additional facts, like, hey, Beal overlooked this fact, that fact. Look at all these things that show. They haven't put forth any evidence, no affidavit, no nothing. He says that the plaintiff alleged that Mr. Wood conspired with Alston and Bird and with Nicholas Sandman. That's simply not true, Your Honor. Your Honor's read the second amended complaint. No allegations at any time have ever said that he conspired with Alston and Bird. We know that. He has said many things about factual allegations, which just aren't in the pleadings. He's pointed to no evidence anywhere. And the law that he cited directly opposes him. They have a duty to put forward a reason. And as the courts noted, this is just an attempt to get some other pockets in there to pay. Now, as we do discovery, if there's some evidence of a conspiracy, we're going to bring it to Your Honor. But right now, we can't in good faith say, hey, we're going to sue these guys. We have no evidence that they did anything. Common sense tells us they didn't do anything. I mean, Rule 1.5 that he relies on says right there, if they were previously members of the same firm, client consent's not necessary. And it took me and my team 15 seconds to find that. We just pulled up the rules of professional responsibility and found it. Now, maybe we are so gifted that we're that much faster than other lawyers. I don't think so. I know Chris and Joey personally. If it took me 15 seconds, it probably took them 14. I doubt that they missed this, or that they overlooked it, or they were somehow part of some grand scheme. But if evidence shows that, well, we change our position.
Well,
But
let me ask you this. Let's say that again, you get some what you would consider, additional smoking gun emails that say Mr. Sandman or Alston Bird attorneys are involved in here. Even if you did then have a viable claim against them, would you still be required to bring it?
no, well, we could. And if we decided, hey, they were instrumental in this, we need to, then that would make sense. But right now, if this court were to force us to add them, they would simply come in here, sit in that chair, file a motion to dismiss, and beat me up. They'd knock me all around the courtroom.
I guess my point being is that let's say this motion gets refiled if this evidence ever appears, even then, would your position be that it shouldn't be granted because you have the right to choose whoever you want to sue in this kind of a claim?
Yes, Your Honor. And I would be able to do that. If for whatever reason we changed our strategy and somehow they became a primary focal point, there was some email where they said, we're going to conspire this whole thing, we're going to do all this, it might make sense. We wouldn't want to try the case with an empty chair. But as co-conspirators, one is liable for the torts of all. So we have absolutely no duty to do this under Georgia law. And we've tried to make that real clear in communications and in pleadings. And there's just simply no basis to the motion. And the sooner we put this behind us, I think that any questions I can answer for Your Honor? Thank you very much.
All right, Mr. Reyes, I'll give you a minute with the last word if you have anything you want to add.
Judge, very briefly. Plaintiffs do raise in their second amended verified complaint at paragraph 6 that there is a conspiracy between Todd McMurtry and Mr. Wood. Whereas he says that there's no such allegation. They did allege that there's a conspiracy. A conspiracy between Mr. Wood and Mr. McMurtry necessarily involves one, he hasn't explained if Sandman and Burby and Markward don't have an interest, what is McMurtry's interest? They have the same interest because they're all part of the alleged fraud. And while they do have, as he states under the 9/11/19, a choice of who to sue, well, case law in Georgia says that while you do have that choice, it is preferable to include all the parties that have an interest in the litigation. And to say that Sandman doesn't have an interest in the litigation when he's the client who Mr. Wood obtained the settlement for, and then this mess entailed when Sandman decided, despite Mr. Wood's request that he consent to the settlement, he said, no, I will not consent unless they provide me their billing records. Of course, he's an interested party. Of course, he's necessary in this litigation. And again, the people who communicated with Mr. Beal as counsel for plaintiffs were Alston and Bird. So if Mr. Wood spoke with Alston and Bird lawyers, hey, let's defraud these plaintiffs, they're indispensable parties. And that's what they're alleging. They're alleging that this is a conspiracy between Mr. Wood and Mr. McMurtry, and they have left out the other parties. So they need to be brought in. Thank you, sir. And again, if I may answer any questions.
No, thank you, Mr. Reyes.
Thank you.
Well, on this particular motion, I think what I was wanting to see if there existed still was a little, if there was any more possible substance on the defense theory. I mean, what you just said was if these certain things exist between the Alston Bird attorneys, and since I don't think there's anything we can point to in the record yet, then it doesn't seem like that's something we could consider at this point. And I also haven't really seen a way to explain how the case law of the plaintiff's kind of unfettered right to choose among joint tortfeasors, how that's not applicable here. So without that being rebutted, I really don't see much to go on here in terms of the failure to join an indispensable party. So on this particular motion, I think I feel comfortable a ruling from the bench on that one. And so I don't see at this point how they could be considered under 9/11/19 as necessary or indispensable. And so I'd ask Mr. Beal if you could prepare a proposed order on that.
Thank you, Your Honor, we will.
All right, let's dive into personal jurisdiction. Take it away.
Good morning, Your Honor.
Good morning.
As I mentioned earlier, I'm Doug Gilfillan. I'm here with Ava Conger from Kilpatrick Townsend, and we represent Todd McMurtry, a Kentucky lawyer, and his law firm, Hemmer DeFrank Wessels.
Welcome to state court.
Thank you. Appreciate that. It's good to be here. Your Honor, this is a Georgia dispute that arose in 2020 between Georgia lawyers who are ending their Georgia relationship. The dispute here is a breach of contract action that plaintiffs have tried to dress up as a fraud case. The plaintiffs have spilled a lot of ink in the second amended complaint and in their opposition to our motion to dismiss. But all that ink cannot conceal that this is a breach of contract action and that the claims against my clients should be dismissed. Plaintiffs are trying to drag Mr. McMurtry and his law firm into this Georgia dispute by accusing them of conspiring with the Wood defendants. However, as shown in our motion to dismiss and in our reply brief and the evidence submitted with it, plaintiffs do not show sufficient evidence to establish a conspiracy for personal jurisdiction purposes, and they don't even allege, much less show, any fraudulent conduct by Mr. McMurtry or his law firm. Your Honor has asked, we're going to take up the personal jurisdiction, so I'll focus on that, and then we'll address the other grounds in our motion to dismiss later.
Yeah, well, and I think we'll probably divide it in half, let plaintiffs go, and then we'll come back to the motion to dismiss if we can, just kind of keep them distinct.
Great. And I'll try to keep this to 10 minutes. Is that your, or would you tell me?
I think you could have more than that. This,
Oh, okay.
this issue seemed to have a little more to explore.
Great, I appreciate that. All right, Your Honor, in considering whether the court has personal jurisdiction over Mr. McMurtry and his law firm, I think fundamental to assessing that issue is understanding what this case is about. Okay, and as I said at the beginning, this case is about the end of the relationship between the plaintiffs and the Wood defendants. It is not about anything that relates to the disputed client or representation in that case or work that was done on that case. There's no dispute in this matter about those things. Today, the plaintiffs submitted a supplemental affidavit from Mr. Wilson with a letter from Mr. Beal. And I noticed towards the bottom of that letter back in February or March of 2020, Mr. Beal acknowledged in his letter that there's no dispute that Mr. McMurtry and his law firm owed a share of the settlement proceeds, the fee from that. He owed that to L. Linwood PC. Not in dispute. Everybody agrees with that. What this case is about is what happens to the money after it goes to L. Linwood PC. Who gets what? Mr. McMurtry has not had sufficient minimum contacts with Georgia to justify and to warrant exercising personal jurisdiction over him. I think under any theory of jurisdiction, I think that's the basic issue that the court has to decide. Plaintiffs don't appear to contend. They don't appear to contend in their response brief that the court has general jurisdiction over Mr. McMurtry and his law firm, and we think that's correct. Obviously, we agree with that. I think the issue is whether the court can exercise specific jurisdiction over Mr. McMurtry under the Georgia's long arm statute or under a conspiracy theory. Both of those theories fail here for the same basic reason. And that is that neither Mr. McMurtry nor his law firm had sufficient minimum contacts. Mr. McMurtry did not purposefully direct his conduct into Georgia. As I'll explain in a few minutes, he got communications from Mr. Wood. He did his own independent assessment, came to some conclusions, and he responded by communicating with Mr. Beal. He then got other communications from Mr. Beal, and he responded. And then later, he got communications from Alston and Bird, a well-known Georgia law firm, and he responded to them. That when the court looks at this case through the right lens and looks at the relevant conducts, relevant contacts before the court, that's what the court has here with respect to Mr. McMurtry's contacts. Obviously, I'll also mention, the court has mentioned, you've read our briefs, but if the fraud claim against the Wood defendants fail, then the conspiracy claim against the Wood defendant, against Mr. McMurtry and his law firm, we're only a defendant in one claim, one substantive claim, I would say, and that's the conspiracy claim. The claim for punitive damages and attorney fees are derivative of the conspiracy claim. So if and when the court dismisses the conspiracy claim, as we contend it should, then the punitive damages and the attorney fees claims would go as well. All right. As I mentioned, this litigation, if Your Honor considers the facts that you have before you, I would ask you to think about them. There are some communications before March 17th of 2020 and when the settlement agreement was signed. And then there's some communications after, months after it was signed on March 17th of 2020. As Mr. McMurtry says in his affidavit, and in particular at paragraph 28 and exhibit 2 to his affidavit, Mr. Wood reached out to him and Mr. McMurtry responded by looking at the issue that was raised, coming to his own conclusion about that, and then he communicated with Mr. Beal. Mr. McMurtry's independent assessment is not evidence of conspiracy. In fact, it's contrary to that. The allegation is that Mr. McMurtry was assisting Mr. Wood in his effort to defraud the plaintiffs. But we show in Mr. McMurtry's affidavit that Mr. McMurtry was not assisting Mr. Wood. He made his own assessment, came to his own conclusion, and responded by communicating with Mr. Beal.
And when we're looking at it from, the issue of just personal jurisdiction as opposed to motion to dismiss, is there any kind of deference owed to the plaintiff's pleadings or to what they put forth, or both of the evidence that the two sides put out on equal grounds? And so the court has to step in and make a credibility finding.
I think the short answer to that is your last question. The answer is yes. As we say in our reply brief, we think the plaintiffs are incorrect that the court has to treat the allegations of the complaint as true for purposes of the personal jurisdiction motion. Our personal jurisdiction motion is filed under 12B2. The other arguments we raise are 12B6. We certainly would agree that for the 12B6 arguments, the court has to accept the allegations of the complaint as true. But for 12B2, our personal jurisdiction motion under Georgia law, it's entirely proper for Mr. McMurtry and for us to have submitted evidence outside the complaint. And the plaintiffs have responded by doing that. And so that presents for you a determination based on the evidence that you have. And so we don't think you have to treat the allegations of the complaint as true.
And so that's where I'm just kind of, my mind's wondering here, because I'm wondering when we've got Mr. McMurtry filing an affidavit saying I acted by myself. We've got the plaintiffs alleging they've got smoking gun emails saying, no, they were conspiring. So they're very much at odds. And generally, to be able to make that kind of determination, we have a witness in the stand subject to cross-examination, and we can really judge their demeanor and how well they hold up. And so how on earth are we supposed to wade through that?
Well, I think it's entirely appropriate for us to, we're comfortable relying on the affidavits. And we think based on the record before the court, that the court should conclude that there's not personal jurisdiction. Court certainly has the discretion, I think, to request live testimony, but we are prepared to rely on the affidavits. Okay. Ms. Conger is helping me a little bit in pointing out that if there are disputed facts, the court does pay some deference to the plaintiffs. But if there's no disputed fact, but our position, and I'll explain this, our position is that there isn't disputed facts, factual matters. There's only speculation and innuendo. And that goes to what Your Honor just mentioned about the plaintiff's contention that they have smoking gun evidence. And
So just to be clear, even in the personal jurisdiction context, we should be giving deference to the plaintiff?
if there are disputed facts.
Okay.
But our position is, and I'm going to explain why, that if Your Honor puts aside the speculation in the innuendo, there aren't sufficient disputed facts to exercise personal jurisdiction or to exercise personal jurisdiction. As I said, I've talked about what Mr. McMurtry offers and what his affidavit shows. What the plaintiffs offer, and again, this is why I go back to looking at this case, what this case is about. If Your Honor puts aside the irrelevant contacts and communications involving Mr. McMurtry and his law firm, you're left with a very small unit of contacts. And those irrelevant communications are communications about representing the disputed client, settling the disputed case. Those contacts are not relevant to this dispute.
Well, and I think the plaintiffs might agree with you there that that's kind of the crux of everything, because they didn't add Mr. McMurtry until they found out about those contacts, right? So that's where it all comes down to, is these emails and that they found. So but you say they're irrelevant, and why is that?
Well, I say these other contacts about the disputed case, trips to Georgia to talk about settlement strategy,
Okay.
Those are irrelevant. What the court has, the relevant contacts for the personal jurisdiction analysis are these. You've got Mr. McMurtry's affidavit. What the plaintiffs offer in rebuttal are 3 emails from Mr. Wood to Mr. McMurtry on February 22nd, 2020. And again, this is Mr. Wilson's affidavit. It's very long. It has 20 attachments, but the relevant ones are the 3 emails from Mr. Wood to Mr. McMurtry that address a lot of things. There's a lot of stuff in there. And what you have besides that is and then you've got Mr. McMurtry sends 2 emails to Mr. Beal. There's nothing in between. The plaintiffs have not offered any evidence of any agreement, any conspiracy, any concerted action that fills in that space between those 3 emails from Mr. Wood to Mr. McMurtry and Mr. McMurtry's email to Mr. Beal, in which he says, I did an independent assessment. Here's what I think is the answer under Kentucky law. Okay. There's nothing for Your Honor to fill in the blank there and conclude that there's a conspiracy, because Mr. McMurtry is saying, I did an independent assessment. Mr. Wilson even attaches a later email. In our reply brief, we cite it as Exhibit G, but that's a typo. My apologies. It should be Exhibit Q. But Exhibit Q is an email from Mr. McMurtry where he specifically says, I'm acting based on my own independent assessment. And that's what Your Honor has in this record. Plaintiffs don't offer evidence that fills in the gap to show that Mr. McMurtry was conspiring or acting to further some plan that Mr. Wood may or may not have had. And so one other issue about what the plaintiffs offer to rebut Mr. McMurtry's affidavit. The plaintiffs cite to one of those February 22nd, 2020 emails and say, well, Mr. Wood told Mr. McMurtry he had agreed to split the fee 50-50 with the plaintiffs. If you look at that email, Mr. Wood says a lot of things in that email. There's a lot of stuff in it. And he says a lot of things about his dealings with the plaintiffs. And so it's cherry picking language and taking it out of context to say that email is a marker in the sand when Todd McMurtry knew that they had an agreement to split the fee 50-50. Because I would submit that's not what that email shows. And then here's the other thing. That email is February 22nd, 2020. The settlement agreement is not signed until March 17th, 2020. What happened between the plaintiffs and Mr. Wood in the interim? All these communications between them, negotiations about the dispute. Mr. McMurtry is not involved in any of those. There's no allegation that he's involved in those. Okay. He's not, there's no evidence, there's no allegation that he's involved in that. And so a communication to him almost a month before, this email a month before, the court shouldn't accept that and conclude based on that Mr. McMurtry knew that there was some agreement between the parties, especially when any agreement or whatever it was didn't happen until almost a month later and may have changed many times in the interim. So that's what I would, and then the other post-March 2020 communications are Mr. McMurtry gets contacted by Alston and Burt, and they basically tell him that they agree on the client consent issue, and he responds to that. Okay. And so those are the relevant minimum contacts that Your Honor has. And they don't rise to the level of supporting personal jurisdiction under a conspiracy theory, nor are they sufficient under a specific jurisdiction or long arm statute theory. I do note in their response brief, the plaintiffs appear to suggest that even their specific jurisdiction theory is an agency theory. And I would say there's no basis to conclude, for the same reasons I've just addressed, there's no basis to conclude that Mr. McMurtry was acting as Mr. Wood's agent, especially when what you do have is an affidavit and an email, including an email that Mr. Wilson submits, that says Mr. McMurtry was acting based on his own independent assessment. I want to briefly address just some of the cases that we think show that what the court would need to find is that Mr. McMurtry purposefully directed his conduct at Georgia. And as I've said, what Your Honor has is Mr. McMurtry responded to contacts from these two parties who are having a Georgia dispute about ending their Georgia relationship. In our brief, we cite McDonald v. St. Joseph's Hospital of Atlanta. And there the court found that a non-resident defendant's telephone conversations with an alleged co-conspirator who had initiated the calls, much like the contacts were initiated by people other than Todd McMurtry here, were not sufficient to support the exercise of personal jurisdiction. And in that case, the court distinguished other cases in which those courts found there were minimum contacts, but the court distinguished those because in those other ones, the non-resident defendant had been doing the initiating, or the telephone conversation was not an isolated instance. So we would submit that that case, contrary to what the defendants say, does support our argument. I do want to address briefly three cases that the plaintiffs cite. The plaintiffs cite and rely on Rudo v. Stubbs. I think that's illustrative because it's a good contrast. Because in Rudo, the court found that it was appropriate to assert personal jurisdiction on a conspiracy theory over an out-of-state defendant. In that case, the two defendants had allegedly conspired to sell some coins to a Georgia buyer. And the essence of the conspiracy was they misrepresented the price of the coins. And the court said a conspiracy jurisdiction was proper because the out-of-state defendant had two phone conversations with the Georgia buyer in which the price of the coins was misrepresented. So the out-of-state defendant made a misrepresentation into Georgia. That's purposeful direction. Nobody alleges that Mr. McMurtry made any misrepresentation or that anything. He was very clear about what his position was. The plaintiffs don't allege that's false. They just don't like it, but there's no allegation that it's false. And then the other thing in Rudo was the out-of-state defendant invoiced the Georgia buyer with the false price for the coins. So again, that's purposeful direction, not what happened and is alleged to have happened here. two other cases. The plaintiff cited a case I'll refer to as Lima. We addressed it in our reply brief. But their personal jurisdiction was based on an insurance broker who was acting as an agent for the out-of-state insured. That's a common factual scenario. In this case, obviously does not involve Mr. McMurtry was not acting as Mr. Wood's agent in the sense of the way an insurance broker acts as an agent for the insured. And then also in that case, the agency itself, there was no question about whether it existed. It was simply, is that a basis to exercise jurisdiction? And then finally, the Sullivan case is similar. There was a divorce. The divorce got settled. The husband and his daughter were then, ex-husband and daughter were in California. The daughter had a power of attorney to act for the ex-husband. She got sued in Georgia. She claimed no personal jurisdiction over me. The Court of Appeals said there is personal jurisdiction because you were involved in the divorce, the underlying divorce, and you have a power of attorney for the ex-husband, and you're involved in that. That is stark contrast to what is here. Mr. McMurtry was not involved in the negotiation of the settlement agreement. He's not a party to it. He got some communications. He made a judgment about it, and he responded. And those are not the kind of minimum contacts that are sufficient to exercise personal jurisdiction over either he or his law firm under any of the theories that the plaintiffs advance.
All right. Thank you, sir.
Thank you.
Another PowerPoint.
Yes.
All right.
Your Honor is going to be delighted. We even have graphics. We got it all.
All right. Let's
All right.
see it.
On the jurisdiction issue, in order to argue this, we kind of have to get into some of the facts, but I'm going to try and keep that real limited. First of all, let's talk about the standard of review. Council has invented a new and interesting standard, and I plan on using it from now on. It's called the sum deference standard. I don't know where that comes from, but it doesn't come from Georgia law. The law in the case is controlled by Alcatraz Media, LLC versus Yahoo, Inc. at 290 Georgia Appeals Reporter 882 in 2008. And it says any dispute as to facts and credibility must be resolved in favor of the party asserting jurisdiction. And I've got a copy of that case for Your Honor, if you don't mind all the scribbling on it. It says in Georgia, a defendant who files a motion to dismiss for lack of personal jurisdiction has the burden of proving lack of jurisdiction. And any disputes of fact in the written submissions supporting and opposing the motion to dismiss are resolved in favor of the party asserting the existence of personal jurisdiction. So far from some deference, it is all deference. Secondly, it seems as though counsel has said, well, you know, you've proven that Wood tried to conspire with my guy over and over again, but you don't have proof that my guy responded and actually did it. And the theory there is maybe appropriate for summary judgment, but certainly not at a motion to dismiss. We have more evidence in support of a fraud conspiracy than any plaintiff. We've got the actual words of one conspirator to another And then that conspirator's response, not back to the original conspirator, but to my clients doing exactly what he asked them to do. And so at a motion to dismiss stage, we're miles ahead of most plaintiffs. To adopt the defendant's idea would be that there's never a chance to have an out-of-state defendant ever brought into Georgia because you can't prove your whole case at the second you file your complaint. Let's see the next slide. In fact, Georgia law has dealt with this, and the court must grant additional discovery before granting defendant's jurisdictional motion. And the Kolb case makes it clear that discovery shall be stayed for 90 days after the filing of such motion or until the ruling of the court on such motion, whichever sooner. We all knew that. The court shall decide the motion to dismiss within 90 days. The court may terminate or modify the stay, but shall not extend the stay. And limited discovery needed to respond shall be permitted until the court rules on such motion. So if Your Honor is inclined to listen to any of this, we've got to have at least 90 days of discovery. And in the Kolb case, Kolb versus Deruda, the Georgia Court of Appeals in 2019 reversed the grant of a motion to dismiss on jurisdictional grounds because they hadn't done the additional discovery. Let's go back to the 32, slide 32. So we're going to have to jump around a little bit before we get back to the law. But I think looking at what kind of evidence we have right now. So the email of February 22nd from Mr. Wood to Mr. McMurtry states, I can explain more to you tomorrow by phone, but I'd like to ask you to consider preparing a letter from you to Beal and a letter signed by the client to you or Beal, making clear that there is express directive that no fees be paid to Jonathan, Taylor, and Nicole, the three plaintiffs, that exceed a quantum merit basis, regardless of any agreement I made or attempted to make to get rid of their foolishness to prevent it from harming my future efforts for, and he refers to the client, and others. That is, they and you should demand that on a fair and reasonable hourly fee, etc. Next. Now, recognize that this is about a month, less than a month, 3 weeks before the final settlement agreement is entered into by Mr. Wood, in which he promises to pay half of the fee. And then also on February 22nd, he says, in short, Jonathan, Taylor, and Nicole are trying to claim 50% of my fee while attempting to stick me with 75% of the outstanding liability owed on the office lease. The next paragraph says, would you please be willing to call me in the morning and let me give you the basic details of what is going on and exactly what I would like for you to consider doing for me and what I would like for you to consider doing for me, which I believe will bring this foolishness to an abrupt and unhappy ending for Taylor, Jonathan, and Nicole. If they realize they're not going to receive blank for the case, they will have no ability to finance their frivolous claims regarding the fees in the remaining office lease. Worst case scenario will be that I'm authorized by my clients to hold my PC's portion of the fee in my escrow account pending final resolution of the disputes between me and WGW. That alone will cut off their ability to finance and publicize their BS claims against me. Next. And skipped it to go down. There you go. I need for you and the client to state in writing that the clients do not, and shall means shall not agree that any fees due to my PC be divided with any other lawyers except on a quantum merit basis. I think he means quantum merit basis, unless he was referring to Meryl Streep there. I don't think he was. I am confident they have the right to control the fees. I'm confident that their right to do so exceeds my right, if any, to be coerced into paying these greedy lawyers 50% of my fee. In short, I need your help and the help of the clients to nip this nonsense in the bud quickly and quietly, if Bill, and he means Beal, receives a letter on Saturday from you, the client, he and his class will quickly realize that they're in deep trouble, as they will not have the financial ability to pay the lawyer or meet their obligations under the lease. Next. And this is the one that counsel was referring to when he said, oh, I don't think it means that he agreed to pay 50%. And I don't think Todd was on notice that he agreed to pay 50%. In combination, our efforts on Saturday will deliver a knockout punch to Taylor, Jonathan, and Nicole. Then we can focus on Sunday where our focus should be. In fact, my sole focus should be in handling the client's case. Game, set, match. If you agree with me, I hope you do. Quantum Merowit is all these greedy, and I think he means lawyers, will get despite my coerced agreement to pay them 50% of a fee at a time when their mutiny and wrongdoing was unknown to me. So he does admit that he was going to pay them 50%. There's a big difference between Quantum Merowit on the, and he quotes the fee, less than $100,000. A free, he means fee, they did not earn and are not entitled to. I'm going to now get some much needed rest. I love you, Todd. You know that to be the truth. Signed, Lynn. So, this is like the old lawyer joke, the police break in and they, the murderer's house, and they see the to-do list and it says kill wife, bury in backyard, collect inheritance. And the defendant says, well, it doesn't say I should do those things. And basically what they've done is they've admitted this entire conspiracy exists, but we can't actually tell what steps Todd took. Instead, they say Todd made his independent recollection. Okay, let's talk about an independent recollection. And we have a slide on this, but I don't think Your Honor needs it. It's simple and it's in the affidavit.
I think what you're saying is the language matched up, right?
Yes, the language matched up. But beyond that, the independent, he was paid, Mr. McMurtry was paid $150,000 in his political campaign from Mr. Wood at this time. He was also paid in a.
Well, I think that was much later, right? The campaign contribution.
We have the exact date in the affidavit and we'll get it while we're.
But I don't think it was like in March of 2020, right? I think
No,
that
but
was
it's before the money comes in. Money comes in July of 2020. So they cut the deal. And so then in June, the payment is made. So it's during this time while they're waiting for the fee. And in addition, he promises him an additional $75,000 out of the fee to help Mr. McMurtry resolve the dispute with a disgruntled partner in the law firm. So, it's like this, Your Honor. If you hired an independent person to investigate a claim in a dispute between two litigants, Your Honor would be furious if you found that one of the parties paid $225,000 in cash on the side to this independent arbiter and then wrote 3 emails detailing exactly what we want the outcome to be. If Your Honor found that we were paying an independent mediator or arbitrator or special master $225,000 on the side and then demanding certain activity, Your Honor would say, Mr. Beal, that's fraud. You have violated your oath as a lawyer and to this court. And Your Honor would be right. They were not independent under any circumstance. And in fact, it's bad faith to even use that term. So
well, it sounds like it again if you're saying, and I'll let Mr. Guilfoyle have the response soon here, but with the deference standard, I don't really see that there's too much to weigh in there and make that kind of final conclusive finding. But I want to ask the cases he brought up. I think they rely heavily on the McDonald case. They cited a few more. Any thoughts on the McDonald case? And this may be maybe this is a situation where no side has a case that's directly on point because it's a fairly unique case. But it seems like McDonald may be one where it was just someone out of state directing, making calls. Why is that distinguishable here, if at all?
Because in McDonald, Your Honor, the court says it would be different if the defendant initiated the calls. It would be different if it weren't just a random isolated call, if it were multiple calls. And so the question becomes, and rightfully so, did the defendant inject himself into a controversy? And here the evidence is overwhelming that he did. We have the evidence of the first communication from Mr. McMurtry to me, Your Honor, and it is attached as an exhibit to an affidavit and was produced by the defendants, although they contest that the affidavit is somehow insufficient. And if we look at this letter, it says, as I write as counsel for, and it describes the disputed client. Lynn Wood has advised me that you represent, I understand. He then threatens me and he says that this is all they are entitled to. And it's odd that that's his first communication with anybody. How the heck would he know what Georgia law is? How the heck would he know what is going on or who I am? He doesn't pick up the phone. He doesn't send an email and say, shoot me a letter with your position in this. I know Lynn's going to be disputing this. How can we resolve this? He does promise to act as the escrow agent for the money. He promises this and then violates it and actually delivers all the money to Lynn Wood. So it becomes the perfect ploy. Hey, don't worry, I'll hold this in escrow for you. And then the money comes out the back door. I mean, that is a clear evidence of being part of a conspiracy. It's a clear evidence of fraud. Secondly, my letter in response. Something. Oh, thanks. My letter in response, I said, it's unusual for me to have a non-adverse counsel introduce himself to me by threatening to sue me and my firm. I am not sure why you felt compelled to threaten me with litigation, but I can see that this is the place we find ourselves. It's obvious to me that you are deeply involved in any dispute which may arise between Mr. Wood and my clients, and that you have injected yourself deeply into any such controversy. Your Honor, I'm not above sneaking in some kind of self-serving comment, but I didn't know we were going to have this standard of review in February 2020. I mean, that's more than 3 years ago. I thought this money was forthcoming and that I was going to just argue with this guy and get this resolved. But my words there are kind of prescient in this case. He has deeply injected himself into the controversy. And I know Your Honor wanted to get into the law, so why don't we skip ahead if you can find that for me in the jurisdiction section. And I do think that the McDonald's case cuts both ways, and it actually cuts in our favor because he did initiate the call. He acted as escrow agent. He was the only person who could prevent us from getting paid. He was the only person, as the emails show, who could convince the client, hey, turn on these guys and demand to see their fees. And Your Honor, we have a whole section on how the client consent is not necessary under Georgia law, but that seems like it's a side issue right now. So I'm not going to waste the court's time with it, but it is clear as a bell that Georgia law does not require client consent. The standard is a defendant moving to dismiss for lack of personal jurisdiction has the burden. The motion should be granted only when there are insufficient facts to support a reasonable inference that the defendant can be subject to the jurisdiction of this court. And that's the Beasley case with the Georgia Supreme Court in 1990. And then the affidavits do not devolve into motions for summary judgment. And that also cites the Alcatraz case. And the reason is that if you need full discovery, you need full discovery. Under the theory of conspiracy jurisdiction, the in-state acts of a resident co-conspirator are imputed to a non-resident under hyperdynamics versus Southridge. All of these cases on conspiracy jurisdiction turn on the concept that he somehow conspired. And counsel has made an argument that, well, take conspiracy out of it and just look at Todd McMurtry individually. Well, you can't take conspiracy out of it because that's our whole claim against him. He wasn't independent. He wasn't neutral. He was highly paid. He was highly influenced. And as Mr. Wood says repeatedly in his emails, and I'm going to fill up your plate with more work. And as the court is well aware, Mr. Wood was capable of doing that at that time. He had a lot. Co-conspirators act as agents of each other in the Rudo case. Due process merely requires the non-resident defendant have taken action purposefully directed toward the forum state. Purposeful availment is satisfied for conspiracy jurisdiction when the alleged conspiracy is targeted at one or more Georgia residents specifically. When the purpose of a conspiracy is to commit an intentional tort against a Georgian, all the co-conspirators are purposefully directing their activities toward Georgia and should anticipate being hauled into court here in Georgia. The cases that the defendant urges this court to look at are devoid of the concept of a conspiracy. And it is also important to note that two of these three emails were not produced by the defendant, Mr. McMurtry, in his production. The only discovery that really happened in the underlying cases, we served a subpoena on Mr. McMurtry. He signed an affidavit that he had given us everything, but he didn't give us these emails.
How'd you get those?
They were from a colleague who had worked with Mr. Wood in another piece of litigation, who contacted my clients and said, you know, there's a reason why he's not paying. What do you mean?
And side issue, I think, and you maybe highlighted in the very first version of this motion to dismiss that was the subject of another discovery contempt motion. Is that still unresolved as well?
There is a contempt motion, but that is against Mr. Wood. The actions of Mr. McMurtry are not subject to any pleadings.
And so but that discovery motion is still floating out there as well. Okay.
He didn't answer a lot of discovery purposefully, and so we filed a motion for contempt on that and to get him to respond. But the important thing is Mr. McMurtry didn't want us to have these, and he signed an affidavit saying, I've given you everything. And then when we said, Todd, look at this other stuff, he said, oh, yeah, well, there's some other things. There's no way he missed this. I mean, the two from is Lynn and the clients. It was everywhere in his outlook. So this shows the difficulty of trying to make a ruling at this early stage on these issues when we've proven 2/3 of the conspiracy, but we got to take some depositions.
Do you agree with the defendant's position that there's no general jurisdiction here? They made a distinction between general and specific jurisdiction. Any thoughts on that?
Your Honor, there is a body of case law which supports the idea that they have conducted business inside the state. And so we went through that. But that is not our primary approach. They acted as escrow agents for Georgia defendants. They failed to make payments to Georgia defendants. They did make an improper payment to another Georgia defendant. They communicated with Georgia defendants on this case and on others. They repeatedly traveled to Georgia to meet in furtherance of their conspiracy and in furtherance of all other business purposes. So yes, we would contend that there is general long arm jurisdiction based upon the meaningful business contacts. At one point, all Mr. McMurtry did was work with Lynn Wood out of Atlanta. That was his whole practice. So there is a meaningful contact with the state of Georgia, but clearly we're not suing him because he was Lynn's pal. We're suing him based on being a co-conspirator in this case. We think the evidence is overwhelming that at a motion to dismiss stage, this jurisdictional motion should be denied. But if the court is at all inclined, we would initiate our request for additional discovery to be able to prove it. But I think with so much out here, it's clear that minimum showings of jurisdiction have been met.
All right. Thank you, Mr. Beal.
Thank you.
All right, Mr. Gilfin. First of all, were you able to review and receive the supplemental affidavit of Taylor Wilson that was, I think we got it about 30 minutes before the hearing?
I looked at it on my phone, Your Honor.
Are there, and obviously you don't have to answer this right now if you're not ready, but do you still have authenticity concerns about the emails that you challenged in your reply brief?
Again, just based on a review on my phone, it looks like they addressed that, and so I don't think so, no.
Okay. So, I mean, it really seems like the stronger hurdle here for you to have to overcome is this deferential standard, when I imagine, at, I don't know how many probably closings you've done where you said, I don't know everything that happened in a conspiracy, but here's one or two things, and all the actions of one, maybe the actions of all, and they're acting in concert together. Isn't that just enough with a deferential standard to get us there?
Well, with respect to the standard, we lay it out in our brief. It's not, I mean, I don't think there's any dispute about what the standard is, but with respect to your question, I would say, and I would say in a closing argument, that what the plaintiffs have are emails that are requests from Mr. Wood. And what we have as far as Mr. McMurtry is his affidavit and his emails. And they are filling in the gaps with speculation and innuendo. And so even under the correct standard, I would say no, that we have met our burden of showing that there's not a sufficient basis to exercise personal jurisdiction based on a conspiracy theory, because Mr. McMurtry's contacts were not purposeful availment, notwithstanding Mr. Beal's self-serving letter in February of 2020, in which he used language that sure does seem like it's intended to manufacture the very personal jurisdiction that they seek to assert now. Notwithstanding that, Mr. McMurtry did not inject himself into the dispute. He was contacted. He looked at the issue. He responded. Mr. Beal, in characterizing, I think it was the email at Exhibit I on Mr. Wilson's affidavit, I think he said that Mr. McMurtry was addressing Georgia law. I think it's clear from the email in Mr. McMurtry's affidavit, he was talking about Kentucky law. Okay. He thought the issue was a Kentucky dispute, which is further evidence that he's not injecting himself into the dispute. Again, the dispute between the plaintiffs and the defendants about what happens to their share of the fee that Mr. Wood did reach out to him about. I think I want to address, if I may briefly, Mr. Beal said a couple times, and I may have misunderstood, but I think he said a couple times that we've admitted the conspiracy exists. I don't think I could be more clear that that's not correct. Secondly, Mr. Beal's belated request for discovery on the jurisdictional issue, they filed a lengthy opposition brief, and they even filed a supplemental affidavit this morning, and they didn't ask for additional discovery. This case is not at the outset, as Your Honor knows. They've had third-party discovery, and this isn't an issue of having to have jurisdictional discovery at the outset of a case when all that's happened is a complaint has been filed. They've had discovery. They didn't ask for it. And they chose to respond to the brief and submit the affidavit and submit the evidence that they have submitted. And as I said, they don't have anything other than self-serving speculation and innuendo about filling in the gaps. I want to address finally, if I may, one big point and then a couple minor points with respect to the campaign contribution to the PAC. Okay. Their own exhibit shows that Mr. Wood made other political contributions. Okay. So this is an example of saying that Mr. Wood's political contribution activity is somehow evidence of improper conduct in this case.
Were there any that high?
It's in the, one can look at the exhibit that's attached to the affidavit.
We're going to put it up for Your Honor.
And of course, those would just be the contributions from that particular account. I think there's, in some of the emails, there may be evidence that he made similarly large contributions in other matters. Also, with respect to the, basically what happens with the $75,000 is that Mr. Wood loaned Mr. McMurtry $75,000. And again, there's no evidence that ties it to the dispute between Mr. Wood and these plaintiffs. Their own exhibit K, is an email that shows Mr. McMurtry and Mr. Wood, they had other business together. The exhibit K shows that there's communication about completely unrelated cases. And so again, it's not sufficient to just point to other things and say, aha, that's evidence of conspiracy. And then finally, I'll finish with 2 points. One is their own affidavit, Mr. Wilson's affidavits, paragraphs 15, 16, and 17, reflect that Mr. McMurtry produced the emails. There were 2 productions, but he produced them. Okay. It's reaching, and it's a stretch to accuse Mr. McMurtry of improper conduct because there were 2 productions involving emails and electronic evidence. That happens all the time. And then finally, Mr. Beal accuses Mr. McMurtry of promising to escrow the funds, and then he didn't. I think what the email says is he offered to do it, and nobody took him up on it. Okay. And so that wasn't a situation where he made some promise and then violated it himself. That was something in his email that he offered to do, and no one ever agreed to that. So unless Your Honor has any other questions on the personal jurisdiction question, I'll just conclude by reiterating that if the court will sift through the innuendo and the speculation, there are not sufficient minimum contacts here to exercise jurisdiction over Mr. McMurtry or his law firm.
All right. Thank you, sir.
Thank you.
Anything based on what he just raised, I'll give you a minute.
Yes, Your Honor. Exhibit O shows that Mr. McMurtry actually received the settlement agreement before he communicated and asserted those claims. So he was fully in league with Mr. Wood. Counsel urges this court to sift through all the evidence. It's not Your Honor's job or duty or responsibility at this point. It's impossible to do it because you would have to decide in favor, decide against credibility of the plaintiffs here, which is not possible under the Alcatraz case. And lastly, I would state, and this is a side issue, but I stand by my earlier allegations that it was not simply 2 productions. Mr. McMurtry signed an affidavit that I've given you everything. And it was only when I confronted him with the missing documents and threatened a bar complaint against him through his counsel, if he didn't give me everything, that his counsel apologized and he produced what we're seeing here today.
Is that correspondence in part of the exhibits or part of your
No, Your
complaint?
Honor, I hadn't planned on getting into all of that. We have it all, but it's not part of this here today, but it does show in Taylor's affidavit, there is portions of it in paragraph 15 on page 4 that he was challenged by me, and I'm not accusing Mr. Gilfillan of anything. He wasn't involved in it back then. He doesn't, and this was years before he got into it. But I think it is noteworthy, and it's going to be a part of this case. A bar complaint was not filed in Kentucky, but it is the affidavit of compliance that he executed will be introduced into evidence, and it'll be a hot subject. But I think that counsel's argument that Your Honor has to sift through all the evidence and make judgment calls answers the question for us. This motion should be denied.
Thank you, Your Honor. Very briefly. On Exhibit O, which Mr. Beal just raised, that's an email from Mr. Wood to his children that he forwarded to Mr. McMurtry. And he said, it says, look at this email to my children. Okay. And then it's a really long email to his kids. He doesn't say, this is a good example of what's going on here. He doesn't say, hey, Todd, look at this settlement agreement. Look what it says. Look what it doesn't say that.
And
He didn't reference the attachment.
the settle agreement's attached in the forward?
It appears to be, yes.
Okay.
Highlighted.
But he doesn't, he says, look at this email to my children. It's 10 o'clock at night. Okay. Second thing I would address with respect to my request for you to sift through the arguments and the evidence, and we're going to see this with the contract arguments and the economic law arguments. I'm asking the court to be very specific about what you have and what you don't have. And not to accept the broad general assertions that the plaintiffs are making and asserting that there's a conspiracy here for jurisdiction purposes. Thank you.
All right. Thank you all. Okay. So I'll be taking that one under advisement, and we will be back with you on that one. So I think what that leaves us with in terms of a longer argument is the motion to dismiss. And my thought is that we can take 5, we come back at noon, give each side 20 minutes, which thereabouts, which will put us at 1 o'clock to then tie up the rest of the loose ends. How does that sound?
Perfect.
Okay. See you in a bit.
Thank you, Your Honor.
Oh, I think that's just our style.
Sure.
Take those out.
You need a bar number?
No, that's fine.
Just one motion to dismiss as it has the personal jurisdiction issue, and then, but we also moved to dismiss based on legal issue.
Okay.
Based on a merger clause and their settlement agreement, we say bars the fraud and conspiracy.
Right.
Really economic loss.
So we have the other arguments coming from you yet in that regard. Because I've lost track of all the motions in this case that are pending, because so many were filed back in 2020 and haven't been.
Yeah, no, well, obviously, you know.
But
we-
you guys are sort of. new to it.
Exactly.
Yes.
Correct. I think that's, so we still are in a narrow posture.
Right, luckily.
Yeah.
Nice job on the Chrisley article. Oh, yeah.
Oh, it's ninja job on I mean, at the end of the day.
Court come to order, remain seated.
All right. Let's go back on the record. We still have several more things to address here. And we'll pick it up with Defendant Wood's motion to dismiss, and I guess and motion to strike, that would still be relevant here. So we could take up both of those. It's been amended along the way. I guess its final form would be from filed May 3rd of this year. So who would be arguing on behalf of Mr. Wood?
I'll be doing that, Your Honor.
Okay, Mr. Reyes. I'm going to cap you at 20 minutes, sir.
Yes, sir. I'm going to address defendants Linwood and Linwood PC's motion to dismiss counts 2 for fraud and fraudulent inducement and count 5 for punitive damages for failure to state a claim under which relief can be granted, and a motion to strike the allegations at paragraphs 111 to 188 of the first verified complaint. The numbers changed by about 26 numbers in the second amended verified complaint as being redundant, immaterial, impertinent, and scandalous. Plaintiffs filed their first amended verified complaint on September 10 of 2020, suing Mr. Wood and his firm over one of 8 cases that were part of the settlement agreement and general release of March 17, 2020. The other 7 cases have been satisfied. There was one pending issue with the Nicholas Sandman case. And the parties had entered into that settlement agreement and general release on March 17, after severing their ties, after the client, Mr. Sandman, requested that the plaintiffs provide to him their billing records before he would consent to the fee split that Mr. Wood had recommended that he consent to, as contemplated in the settlement agreement of March 17. Plaintiffs refused to provide their billing records to Mr. Sandman and instead sued Mr. Wood and his firm for the 5 counts that I already mentioned. To date, the plaintiffs still have not provided Mr. Sandman with their billing records. Importantly, it is the parents of Nicholas Sandman who was a minor at the time, who hired Mr. Wood and his firm in January of 2019 to represent Mr. Sandman, who at the time was a 16-year-old high school student who was involved in high-profile defamation lawsuits following the media's false and defamatory statements about him when he attended a protest in Washington, D.C. In favor of life. The minor client's parents engaged Mr. Wood, known for his winning skills in defamation cases for decades, and did not engage Wade, Grunberg, or Wilson, unknown to them. One of the lawsuits filed on behalf of Nicholas Sandman settled in early 2020, before the settlement agreement and general release of March 17, 2020. However, due to the COVID lockdowns, the probate court in Kentucky closed down also in March of 2020, a few days after the settlement agreement. The client's local counsel, Todd McMurtry, did not receive the settlement funds in his trust account until late July 2020. So we have a gap between March and July, by which time Nicholas Sandman had already turned 18. So we would be no longer dealing with mom and dad. Now there was a new party in the equation. It was the adult Mr. Sandman. So instead of his parents having to consent to the fee split, and instead of a probate court in Kentucky having to agree to it, it was now upon Nicholas Sandman to consent to the fee split. We must remember that at the time that the parties, plaintiffs and defendants, entered into the settlement agreement on March 17, 2020, they were no longer working in one office space. They had their own independent law firms. On July 24, 2020, Nicholas Sandman met with his local counsel, Todd McMurtry, and learned that Mr. Wood would be paying $843,750 to the plaintiffs, Wade, Grunberg, and Wilson, on his settle case. And that Lynn Wood had asked that said fees, as contemplated in the settlement agreement, be authorized. This is the consent that Mr. Wood provides to Nicholas Sandman to sign, agreeing to the fee split. The consent of Nicholas Sandman. I have reviewed the settlement agreement and mutual release between L. Lynn Wood, PC, and L. Lynn Wood on the one hand, and Wade, Grunberg, and Wilson, LLC, Nicole Wade, Wade Law, LLC, Jonathan Grunberg, JD, Grunberg, LLC, Taylor Wilson, G. Taylor Wilson, LLC, and Grunberg and Wilson, LLC on the other hand. Todd B. McMurtry, my legal counsel, has indicated that L. Lynn Wood requests that I consent to this agreement. Accordingly, I hereby consent to this agreement, and there's a line for Nicholas Sandman to sign, which he did not sign. He declined to sign that consent form until he could review their billing records, the plaintiff's billing records, so he could determine what work they had performed in his case, since they were asking for almost $1 million. Instead of providing their billing records, they sued Mr. Wood and his firm, as if suing Mr. Wood would somehow do away with their ethical duties towards Nicholas Sandman, who had requested their billing records on his case. Plaintiff sued defendant in this court and affirmed the settlement agreement and general release, which is Exhibit A to their verified complaint, as they sued for its alleged breach. That act of affirming the contract between the parties and suing for its alleged breach in count 1 bars plaintiff's ability to assert additional claims for fraudulent inducement and fraud in count 2 and punitive damages in count 5. Additionally, the terms of that contract, which include an entire agreement or a merger clause, also bar any fraudulent claims based on alleged statements or representations made outside of the contract. Plaintiff's fraud and punitive damages claims lack any arguable basis in Georgia law.
Mr. Reyes, this may be redundant, but since it's kind of similarly phrased, but
Yes,
where
sir.
in the settlement agreement Exhibit A, because there's so many redactions, which part of this is talking about the client that that's the kind of the
Let me
basis
look
of
at
this dispute?
settlement agreement, sir.
Because,
One. On page 1, Your Honor, number 1A, Roman numeral 3, Sandman versus CNN.
Okay, mine's redacted, so that's
Oh, I'm
why.
sorry. May
All I have
approach?
is, yeah, well, yeah, that'd be helpful. Thank you.
Yes, sir. Bottom of the page.
Your Honor, all
Mr.
this, is governed by a confidentiality agreement between Mr. Wood, the plaintiffs, and
Should I give this back then?
the defendant. No, it's fine, but I just don't want to be reading
No.
numbers out in open court that could be seen by a third party, because part of their duties are to keep it confidential. So Your Honor should see it, and we could, just not say numbers out loud because it's highly confidential.
Sure.
That's why we.
Even though I think these numbers and things have at this point already become part of the record.
Figured it out a long time ago and
Yeah.
just put it all over the place. So I think.
Mr. Gelfand?
Yes, Your Honor, thank you. I was gonna agree basically with what Mr. Beal was saying. Everybody here is subject to a confidentiality agreement. And I guess the concern I have I'm fine with Your Honor looking at it, but if it becomes a part of the record, I think it should be sealed. And also, I actually don't think it needs to be part of the record. I understand why you want to know what part's the issue. Totally agree with that. But
I don't need all of it. I just needed to know which clause. So it's gonna be 1A3. That's, I think, all I really needed to know.
Importantly, this agreement was negotiated by Alston and Bird with Mr. Beal's office. I was addressing the merger clause. And plaintiffs present these allegations as detailed facts pertinent to their fraud claim. But of course, all prior statements by the parties related to the settlement agreement and release are irrelevant to the merger, are irrelevant due to the merger clause. Plaintiffs acknowledge at paragraph 177 of their first amended verified complaint, which would be like 26 more numbers in the second one, that when the settlement agreement was being negotiated and drafted, they were aware of Georgia Rule of Professional Conduct 1.5, which provides in subsection E that lawyers who are not in the same firm may only divide a fee if certain conditions are met, including if the division is in proportion to the services performed by each lawyer, and the client is advised of the share that each lawyer is to receive and does not object to the participation of all the lawyers involved. Despite this, the settlement agreement included no representation on the part of Linwood PC that the clients in the cases where it would be splitting its fee with Wade, Grunberg, and Wilson with the plaintiffs had consented to such fee splits, nor any covenant on the part of L. Linwood PC to obtain the client's consent after the settlement agreement and general release was executed. That was never discussed between plaintiff and defendant. Moreover, plaintiffs do not allege in their complaint that they ever asked for any representations or warranties from Mr. Wood or his firm on this point. And plaintiffs do not allege that they asked for any such provisions to be included in the settlement agreement. They did not. In other words, they were aware that Rule 1.5 of the Georgia Rules of Professional Conduct could become an issue where the client could ask for billing records, and it did become an issue. Despite that, they, the plaintiffs and or their lawyer, didn't do anything about it. They could have done some things. They could have introduced into the contract additional language, a warranty that Mr. Wood would have paid them no matter what. I would pay you this amount irrespective of anything else. They didn't do that. Additionally, they claim that they negotiated, the plaintiffs, the language of these recitals in such a way as to render, in their opinion, Rule 1.5 inapplicable to the fee splits, eliminating the need for the clients, including Mr. Sandman, to consent to them. Interestingly, plaintiffs failed to explain how the parties in this case could have agreed amongst themselves to circumvent Rule 1.5 if the client chose that he wanted to review billing records before he gave his consent. A lawyer cannot do that. A lawyer cannot circumvent the Georgia Rules of Professional Conduct. Yet, knowing that, they didn't do anything about it. In their complaint, plaintiffs avoid mentioning that this lawsuit arose when a client asked, Mr. Sandman asked for the billing records, and they refused to provide them. It is a breach of their ethical duties towards Mr. Sandman. And that's why we're here. When Mr. Sandman refused to the consent because they wouldn't provide records, they sued Mr. Wood. They could have simply provided the records to Mr. Sandman. They didn't. Regardless of their motivation for filing, one thing is crucial to the court's analysis of this motion, and it's beyond any dispute. When plaintiffs filed their complaint in this court, plaintiffs affirmed the settlement agreement and sued for its alleged breach. The act of affirming the contract between the parties and suing for its alleged breach bars plaintiffs' ability to assert additional claims for fraud and fraud in the inducement and punitive damages. Moreover, the terms of that contract, which include an entire agreement or merger clause, also bar any fraudulent inducement claim based on alleged statements or representations made outside of the contract. Now let's address what the plaintiffs brought up afterwards, which is in a hollow attempt of circumventing Georgia law by referring to their newly acquired evidence in their January 3, 2022 supplemental brief in opposition to our motion to dismiss, they claim that Lynn Wood, at the time he signed the settlement agreement on March 17, 2020, had no present intent to perform, but conveniently ignore the facts that negate.
Mentioned the present intent argument was not in the very first complaint.
It was not.
It was not there in the first
It
one.
was
That
not.
only came up after.
It came out after.
Okay. And so it seems like counsel for Mr. McMurdy and the plaintiffs have found or highlighted these line of cases that provide something of an exception to the merger arguments about present intent. Do you also
Sure.
believe that that is an exception if it's present here?
It's not present because present intent requires that the ill will to not perform on the contract happens at the time of the settlement. And I will give you examples from our cases and from their cases. Each case that plaintiffs cite in support of their present intent argument, all of them without exception, the ill will communications happen at the settlement on that date or the day after or afterwards. Never 3 weeks before, never 4 weeks before, as in this case. For plaintiffs to try to convince anyone that a settlement that was entered on March 17, 2020 should have been all good since a month before is illusory. The truth is that these two bands were fighting each other tooth and nail for a while. It came a time when Mr. Wood decided to end it. It came a time when Mr. Wood said, listen, I understand that they should not be entitled to anything more than quantum merit. I understand that I shouldn't have to give them that much. But that happened a month, 3 weeks before. Then the lawyers get involved. Mr. Wood has other issues to worry about. He has a meeting with President Trump coming up. He's trying to obtain a post-mortem Presidential Medal of Honor for Richard Jewell, who's deceased. And so he does not want, for what they ended up doing, which was filing a lawsuit full of language that is very critical of him. He didn't want that out there so it could prejudice his Richard Jewell agenda, or that it would prejudice the other cases regarding Nicholas Sandman that he had settled with CNN, but there were other NBC, et cetera, that had also defamed this kid. So Mr. Wood decided with his lawyers, it's over. I'm going to pay them. Let's enter into the settlement. They settled the case, March 17, 2020. From that moment forward, there's no communications between Mr. Wood and anyone else. The only things that Mr. Wood does after that date is that he offers the plaintiffs a $500,000 line of credit when they all realize that the settlement is not going to happen in March because the probate court in Kentucky is closed because of the COVID-19 lockdown. So Mr. Wood offers them a $500,000 line of credit. He refers to them 37 cases in that interim. These are not the acts of someone who wants to deceive, who wants to defraud someone else. Mr. Wood's communications with Mr. McMurtry happened on February 22 and all the way to March 4. The settlement is on March 17. I'm going to go over some facts and some case law that explains how their argument of present intent and at the time is flawed. They're trying to put lipstick on a pig and make it look like a girlfriend. It's not, it's a pig.
All right, less than 5 minutes, sir.
Yes, sir. They also mentioned these emails and they called them the smoking guns. There are no smoking guns in this case. On November 9, 2020, approximately 1 year before the new emails were discovered, plaintiffs had asserted in their brief in opposition to defendant's motion to dismiss at page 8 that 2 days later, on February 22, 2020, Wood stated that the client in the disputed case, Sandman, will only agree at best to pay to WGW plaintiffs quantum merit for their services, which will be very difficult for WGW to calculate. Clearly, plaintiffs knew as early as February 22, 2020, 1 month before the March 17, 2020 execution of the settlement agreement, of defendants' pre-contractual intentions regarding the quantum merit, and readily acknowledged that defendant Wood had voiced his intention that they would not get one thin dime from me on any case. They knew all this. So there's no smoking gun that surfaces after. They know about this way before. Plaintiffs' efforts to cast pre-contractual discussions and negotiations that occurred between February 22 and March 4 of 2020, as if they had occurred on or after March 17, 2020, the date of the settlement agreement, falls flat on its face in light of their concession that they knew about this since November 9, 2020. It defeats their argument. I'm going to go to the case law since I have limited time. Plaintiffs had to make, well, I'll get past that. The fraud and fraudulent inducement and claim in count 2 was barred as a matter of law by plaintiff's election in count 1 to affirm the settlement agreement and sue for its alleged breach, where a party who is entitled to rescind a contract freely and advisedly does anything which amounts to a recognition of the transaction or acts in a manner inconsistent with repudiation of the contract, such conduct amounts to acquiescence and the contract becomes unimpeachable in equity. That's Meadow River Lumber Company versus University of Georgia Research Foundation, 233 Georgia App 169 at pages 175, 176, 1998. Plaintiff's fraud claim is barred as a matter of law and should be dismissed. On the fraud claim in count 2 is also barred because plaintiffs cannot convert a breach of contract claim into a tort. The Georgia Supreme Court plainly stated in A.L. Williams and Associates versus Faircloth, 259 Georgia 767, a 1989 case, that a plaintiff's allegations cannot convert a claim in contract into a discrete claim in tort. Under this precedent, a breach of contract does not give rise to an action for tort, whether or not such breach was negligent or willful. Indeed, Georgia law describes torts, which include fraud claims, as the unlawful violation of a private legal right other than a mere breach of a contract. That's OCGA at 5111. Georgia courts have followed this reasoning and dismissed breach of contract claims attempting to masquerade as fraud claims. One instance, Service Master Company versus Morton, 252 Georgia App 751, in which the Georgia Court of Appeals reversed the trial court's denial of a motion to dismiss the plaintiff's fraud claim where the alleged fraud related exclusively to the defendant's failure to perform the terms of a contract, as is the case here. Relying on the holding in Faircloth, the court held that the fraud claim should have been dismissed where the defendant's alleged breaches of duty arose directly from not independent of the contract. Such is the case here. These cases forbid precisely what the plaintiffs seek to do here. Describe alleged bad faith by the defendants in breaching the settlement agreement to purportedly support a claim that they were defrauded. But no matter how allegedly egregious a defendant's breach of contract is, that breach is only a breach of contract. It doesn't convert into a tort as they wish to do. Plaintiffs would like to have the court believe that their case is different from the general rule and subject to the present intent exception. Not so. In none of those cases relied upon by the plaintiffs, those courts rely on pre-settlement discussions, arguments, or negotiations preceding the settlement, but rather they relied on the defendant's conduct during and after the settlement. For example, the plaintiffs rely on JTH Tax Inc. versus Flowers, 691 Southeast 2nd, 637. In that case, in JTH, the court found that the Liberty Tax, the buyer of the tax preparation business from Flowers, had no present intent to perform at the time the agreement was executed. That's not the case here, where at the time the parties signed the settlement agreement and general release, it was imminent that the Kentucky probate court would approve the settlement that month, within March, before the COVID lockdown. We didn't know there would be a COVID lockdown within days. And before the client turned 18 and requested from his counsel in Kentucky, McMurtry, to review the billing records of plaintiffs before he could consent to the fee split. None of this was foreseeable. None of this was an issue on March 17, 2020, when Mr. Wood signed the release, ready, willing, and able to pay these plaintiffs the amount that they had agreed to.
All right, last point, Mr. Reyes.
Yes.
Problem with these guys in February was what they're doing with.
The court should know that the issues that plaintiffs and Mr. Wood were having before the settlement agreement in February, it really had nothing to do with the amount of the fee split. It had to do with the involvement that the plaintiffs were having with his children. And he was very upset about that. And as counsel for McMurtry raised earlier, plaintiff's counsel is nitpicking from the messages, but if you read the entire message, most of the message is about his kids asking them to stay away. Mr. Wood was very upset, and because of that, he said, these guys are not entitled to anything, but that's in February. Then we come to March 17, 2020. He settles, he has bigger fish to fry. He wants to move on. They won't let him.
All right, thank you, Mr. Reyes.
Thank you, sir.
I think I should, let's keep it with the defendants with the burden. We'll turn over to Mr. McMurtry's
Thank you, Your Honor. I'll do
argument.
that.
Oh, so I think since they're making a similar argument, we'll let them do their portion and then you can respond to both.
I was just going to respond to his real briefly, but not get into all the case law and do them both, because otherwise I might be up here for a while.
Well, I'll give you a little extra time to, because I think their arguments overlap to some extent. So it makes sense to have all of the defendant's motions to dismiss arguments at once. Then you can respond to both. That was the thought anyway.
Okay. Yes, Your Honor.
All right. Who do we have?
Me, Your Honor.
Okay.
Your Honor, the McMurtry defendants have moved to dismiss under 12B6 the fraud claim and the corresponding conspiracy claim on which it's based for two reasons, okay? The first reason is based on the merger agreement and the settlement agreement. The second reason is the economic loss rule. I want to first address the merger clause issue, okay? I think the parties agree, and by parties I mean myself and the plaintiffs, that a merger clause in the settlement agreement bars the plaintiffs from relying on a misrepresentation that's not set forth in the agreement. The dispute here and where we differ is what rises to the level or what is a misrepresentation that is set forth in the agreement. I think that's the difference between the plaintiffs and us. I'm going to jump ahead a little bit, but I think Brock v. King, which we cite in our reply brief, squarely addresses this issue, and the Court of Appeals rejected the argument that the plaintiffs made. But before I get there, I want to address a few things first. What the plaintiffs are arguing is that it's enough to avoid the merger clause to allege that the misrepresentation is that the Wood defendants had no present intent to perform their obligations under the contract. The plaintiff's argument is that satisfies that exception to the merger clause rule. However, the case that the plaintiffs don't cite a single case that stands for that proposition. Okay, they cite cases that stand for two other propositions. That those two other propositions do not answer the question that is presented by the difference between the plaintiffs and Mr. McMurtry here. Those two propositions are this. First, some of the cases that the plaintiffs cite stand for the proposition that in some circumstances, a present intent not to perform can support a separate fraud claim in addition to the breach of contract case, okay? But as I'll discuss in a second, those cases are not merger clause cases, and those courts did not address that proposition in the context of a merger clause issue, okay? It's a different proposition. The other set of or line of cases that the plaintiffs rely on stand for this proposition, that a factual misrepresentation contained within a contract can support a claim for fraudulent inducement, even in the presence of a merger clause. That's just the basic exception that I think we agree on. The plaintiff's fraud claim and the conspiracy claim should be dismissed here because plaintiffs have not alleged a factual misrepresentation that falls within that exception. Okay. The cases that they cite, JTH Tax Inc. versus Flowers, it's not a merger clause case. Okay. That court addressed whether in some circumstances a plaintiff can maintain a fraud claim for present intent not to perform, but not a merger clause case. Bradley versus British Fitting Group, PLC, not a merger clause case. Just that general proposition of in what circumstances a present intent not to perform can support a fraud claim. Minor versus Harrison, cited in several places in their brief. Again, not a merger clause case, just that general proposition, but not addressing the issue of the exception to the merger clause rule. Gaines versus Crompton and Knowles. That case, the contracted issue did have a merger clause, but what the Court of Appeals said is that that merger clause did not merge representations into the contract, okay? That's different than this settlement agreement. So that's one reason that case is distinguishable. And then second, the Gaines court said, quote, their claim, the plaintiffs in that case, their claim of fraud is based on alleged misrepresentations by appellant in the contract itself, end quote. Okay. That distinguishes that case from this case.
Because your position is that there's nothing in the settlement agreement that is a misrepresentation.
The plaintiffs do not, that's correct. The short answer is yes. The plaintiffs do not allege a factual misrepresentation on the face of the contract. And I'm going to get to, I think Brock v. King explains why when if the answer to that question is yes, why under Georgia law, their fraud claim fails. That's Brock v. King.
So in paragraph 1A, where it says the defendant shall pay a portion of its fees, and that portion under 1A3 is apparently the $800,000 figure, and the defendant did not end up paying as they promised they shall. How is that not a misrepresentation?
That is a promise of performance. And that's a promise of performance. And that's why this case, I started off by saying earlier today, this is a breach of contract case, because Mr. Wood made a promise in that contract to which the McMurtry defendants are not a party. It's not my issue, whether that's breach or not. But that's a breach of contract issue. And what the plaintiffs are doing is also wanting to sue in fraud and to hang a fraud claim on that same language that you just quoted by saying that a present intent not to perform is sufficient to avoid the merger clause and that it satisfies this exception. But in Brock v. King, which is 279 Georgia App 335, 2006, the Georgia Court of Appeals rejected the very argument that the plaintiffs make here, okay? Brock v. King was a land seller who sold some property to a developer. And then when the developer didn't do with the property what the seller believed the developer had promised to do, the seller sued on breach of contract and fraud. So in other words, like the plaintiffs here, affirmed the contract, sued for breach of contract, but then also brought a fraud claim. The trial court granted a directed verdict on the plaintiff's fraud claim, finding that it was barred by a contractual merger agreement. On appeal, the plaintiff argued the merger clause did not bar his fraud claim, that defendant had signed the contract with no intention of fulfilling his promises. That's the same argument that these plaintiffs make here. The court rejected that argument, affirmed the trial court. The reasoning, okay, in Brock v. King, quote, plaintiff failed to show that any provision of the contract was false on its face, end quote, and that having sued to enforce the contract, the plaintiff could not also sue for fraud. Okay, that makes sense, okay? It makes sense because a present intent not to perform doesn't appear on the face of the contract, but the exception to the merger clause rule is for misrepresentations that appear on the face of the contract. And so we would ask the court to dismiss the fraud claim because of the merger clause and the corresponding conspiracy claim. This is a breach of contract case, and that's what the court will have left is a breach of contract, which is we're not proper defendants to that. Unless the court has any other questions about this, I'd like to turn to the economic loss rule.
So I think there was one thing on Brock. I think there was a quote from there where the Court of Appeals pointed out that they could find no evidence of an intent not to perform. And that seems pretty crucial to this case.
Your Honor, I think the court addressed alternate issues, perhaps. I would want to look at the case and pull it up and see, but I think the portion of the, okay. Mr. Ray has just handed me the case. Obviously that case arose in a different context, but still the court said first, and then made the finding that I think you're looking at. The court, first looked at the issue that you're now looking at, but then second, an alternate reason. Okay. So two reasons, each taking the opinion on its face are independent of each other. Because I think in the second part that addresses the effect of the merger clause, the court, I don't believe, refers to its finding on the first. It says, Brock failed to show that any provision of the contract was false on its face. The court did not err by directing a verdict for defendants on the fraud claim, and we affirm the judgment against Brock on that claim.
So how does economic loss play in here?
Yes. Okay. Economic loss is a second reason to dismiss the fraud claim, and then as a result, the conspiracy claim. The economic loss rule in relevant part and I think is relevant to this case, because I think there are parts of it that aren't relevant to this case. But the economic loss rule generally provides that a contracting party who suffers purely economic losses must seek his remedy in contract and not in tort. The purpose of the rule is to prevent parties to a contract from always being able to turn a breach of contract case into a tort case. And in relevant part in this case, because the plaintiffs have alleged a purely economic loss that flows from the breach of contract, the only damages they allege are their share of the disputed fee. That's the alleged damages. That's what they seek. That's breach of contract damages. They do not allege any injury to person or property that would be non-economic losses. They don't allege that. This is a breach of contract case. The damages that they allege are their share of the disputed fee that they say they're due under the settlement agreement. There's no alleged injury to person or property from fraud or any other tort. The plaintiff, well, in our motion to dismiss, we argued, we acknowledge there's, like every rule, there's an exception. There is an exception for misrepresentations, okay? There's an exception to the economic loss rule for misrepresentation. And we argued that that exception applies where a defendant is providing professional services or acting in the course of their business or involved in a transaction involving a pecuniary interest, okay? And we would argue, and that exception does not apply here because Mr. Wood was not acting in his professional capacity. He and the plaintiffs were just resolving a dispute about what to do with this money. He wasn't their lawyer. He wasn't providing them advice. They weren't his lawyer. They're just two parties that were settling a dispute about what to do with some money. And so that misrepresentation exception does not apply because if you look at every case that addresses that we found or that's been cited that addresses the misrepresentation exception, they go back to the restatement of tort section 552, or they go back to a case that goes back to that restatement of torts. And the Georgia courts all uniformly say that based on that restatement, the misrepresentation exception applies where the claim arises out of one's business, profession, employment, or in any transaction in which he has a pecuniary interest, okay? Plaintiff's claim here for breach of contract of the settlement agreement does not arise out of the way these courts are applying it, anybody's business or profession or a transaction. In other words, if Mr. Wood had represented the plaintiffs and they were suing him because they were his client and he was their lawyer, maybe that's, you might get to that satisfying that threshold requirement, but that's not what happened here. And so I thought it was interesting that in their response brief, the plaintiffs actually don't address the argument that we made in our motion to dismiss. They sidestep it. They don't take it on. I don't think that they show that it's incorrect. They sidestep it and they try to say, hey, the economic loss rule and they say the misrepresentation exception applies to all intentional torts. And so they say the misrepresentation exception is good. We can bring any intentional tort and we're not bound by the economic loss rule. Again, if you, to use the words I used earlier, sift through their arguments and their cases, and I think read those cases very carefully, none of the cases that they cite stand for that proposition. Plaintiffs, for example, their cite to Johnson versus 3M is instructive. They cite to that case for the proposition that the misrepresentation exception means that all intentional torts are fair game. But that language that they rely on, like many federal decisions, the federal court set out 2 or 3 paragraphs of black letter law, and they've picked a sentence from the middle of it. But the case doesn't have anything to do with whether all intentional torts fit within the misrepresentation exception. And so because plaintiffs at bottom, they don't allege injury to person or property. They allege breach of contract damages. That's why when I began this morning, I started off by saying this is a breach of contract case. And the proper parties to that case under the law that's applicable to their fraud case and their conspiracy case would show and means that the McMurtry defendants are not proper parties and that their claims fail against the McMurtry defendants as a matter of law. The plaintiffs cite a case Murray versus ILG Tech in their briefing. And that case said the economic loss rule applies in tort actions where a plaintiff seeks purely economic damages. Now, it didn't say negligent tort actions. It said tort actions. Okay. So because they don't have any alleged injury to person or property, because they allege breach of contract damages, the court should dismiss the fraud claim and then also the conspiracy claim. And then, of course, I know it's in our brief and I know Your Honor will see this, but because the conspiracy claim fails as a matter of law, so too the claim for punitive damages and the claim for attorney's fees against the McMurtry defendants. And so the McMurtry defendants should be dismissed from this case. I would ask the court reject the effort here to hang a legally flawed fraud cause of action on what is a breach of contract case. Thank you, Judge.
If anyone else needs to step out, we'll just hold in place.
You have to wait on me,
You want us to keep arguing without you?
please.
Must be that entertaining. Okay. All right. Well, in that case, Mr. Veal, let's dive ahead.
Thank you, Your Honor. Responding first to Mr. Wood's argument, not sure what the argument was because it's very different from his brief. None of the information that he talks about is in the record. None of the information is accurate and none can be considered by this court on a 12B motion. This was his idea about what the law or what the facts should be. That's fascinating. But it is not in the record. It's not agreed to by the parties. They can only go on what's in the second amended complaint. So not sure what all that talk was about a loan and referring cases, but none of that's can be considered by this court. And we would contend that the loan is evidence of the fraud because instead of paying Your Honor the $1 million that I owe you, I'm going to make you a $500,000 loan. I mean, which would Your Honor prefer? Probably the $1 million you don't have to pay back. So I'm not sure what all of that relates to. They did make some allegations about a present intent not to perform and said that it wasn't in the first complaint. Indeed, it was, Your Honor. And I know because I drafted it. And the second amended complaint merely incorporates by reference. We cut and pasted everything. So it was in the first, it's in the second amended complaint. I have no idea what he's talking about. Next, the emails that we've referred to in this case show the plan, the prior animus, the fighting, threatening to kill, to attack, to defame, to whatever, all of the plaintiffs shows in intent to defraud. The defraud was indeed, the fraudulent claims are well pled in here. This is not essential to this case, but since council talked about it a lot, I thought we should go through it. Rule 1.5E, a division of a fee between
I mean,
lawyers.
I think that goes more to like the merits and kind of
Or
the,
does.
well, let me ask you this though. So all this conduct, kind of this is more getting into the motion to strike. There's several dozen, if not more than that, paragraphs about kind of the relationship leading up to the signing of the settlement agreement. And I think the argument on the other side is, how is that fraud if that was what was actually happening between them? And your clients knew about this relationship and these statements of quantum merit. How are those relevant to the fraud claim? I know you're saying it shows the intent to eventually violate it, but I guess what I'm getting at is if they knew that that intent was there, why did they sign the agreement?
Because the agreement was binding on its face. So the case law, and we've got some slides on it later that will show that all of this prior conduct is indeed relevant in every one of these cases to show the intent of the parties. Was there an intent to defraud? It is not to show, oh, we've got a claim against him for saying something nasty or choking Mr. Grunberg or any of this other behavior, but it shows an intent to defraud. And the case law looks at exactly that and says that that evidence is indeed relevant, as well as post conduct, to show whether someone had a fraudulent intent, because we are intending to show that he did not intend to perform at the time he signed. The rule 1.5 makes it pretty clear that this paragraph does not prohibit or regulate division of fees to be received in the future for work done when lawyers were previously associated in a law firm. And so this entire argument is a red herring. And indeed, the lawyers were members of the same firm. And Mr. McMurtry even submitted an application for them to be admitted pro hoc vice and represented that they were partners of L. Linwood PC. And so we have one for each of them. And there were numerous filings with the court that showed that they were indeed lawyers of the firm. So that entire argument is a red herring. The Supreme Court has held that with respect to an initial motion to dismiss, that a claim for fraud should not be dismissed unless it appears beyond doubt that the pleader can prove no set of facts in support of the claim which would entitle him to relief, and that the remedy at that stage of the pleading is not a motion to dismiss, but a motion for a more definite statement. So clearly, in the event that this court determines that some portion of what we've alleged is insufficient, a motion for more definite statement is what's required. In Tech BIOS, which we're going to talk about, motion to dismiss for failure to state a claim. The allegations of the complaint disclose with certainty that the claimant would not be entitled to relief under any state of provable facts asserted in support thereof. Could not possibly introduce evidence within the framework of the complaint sufficient to grant an award. All facts in the second amended complaint must be deemed mistakenly listed as first amendment complaint. The second amended complaint must be deemed true. Georgia law of fraud on claims with breach of contract. All of these cases involve the law in Georgia that one can bring a claim for fraud when there is a present intent not to perform. So most of Mr. Wood's argument says that you cannot bring a claim for fraud and a claim for breach of fiduciary duty, especially not when there's a merger clause or release. And these cases make short order of that argument. Well, let's go back. And the first background to it is fraud in a contract, as opposed to pre-contractual promises, allows the party to sue for fraud while affirming the contract. And that's what counsel agreed to when he said if there's fraud in the contract.
So I think that's their main point from the McMurdy side. Where is the fraud in this contract?
That is in the form of a present intent not to perform. And if we look at Roman numeral 3, well, the second talks about how merger and release clauses don't bar a claim for fraud when the fraud is found in the contract itself.
And so does it have to be something explicitly spelled out in here that is wrong? Or is
No.
it just some of the greater intent that you're saying is extraneous to the document itself?
It is the greater intent. It is the intent not to perform at the time they were signed. And so most instructive here, rather than going through the history of all this, we can look at Roman numeral 4. A party's intent not to perform a contract constitutes fraud within a contract, and such fraud claims are not barred by a merger or release language. And if we can skip over to Bradley on 22. What happened in Bradley? A guy signed a release with his employer, took the money, and he was from Great Britain. And he always intended to sue his employer again for whatever torts he alleged happened in the workplace over in Great Britain. So he signed this release that said, you give up forever and ever and ever, and you will never sue us again, and you promise and swear. And he signed that. But the evidence came out that he intended to breach this agreement immediately. And so in the complaint, they said they filed suit for fraud and for breach of contract when he filed a second lawsuit. And the Court of Appeals held, and this was on summary judgment, not on a motion to dismiss. They said the evidence seems clear that he intended to file suit in Great Britain immediately after he signed the release here in Georgia, and that constitutes fraud, and it escapes all the language of the release, which would even be broader than a merger clause. And the court says, because at the time he signed it, he never intended to perform, as evidenced by the fact that he signed very shortly thereafter in Great Britain. And then when they took his deposition, he said, yes, I had planned on doing that from the beginning. And so the court said those two could be brought together. The most important case for us here today is the next one, Gaines versus Crompton and Knowles. And in Gaines versus Crompton Knowles, the important thing is that there was a release, and the parties entered into a release, and the Georgia Court of Appeals said that the present intent not to perform meant that a claim for fraud could be brought as well as breach of contract. And in addition, the language of the release had no effect. And as counsels pointed out, there was a merger clause there also. And the most important thing about the merger clause is, what does the court say about it? Appellant also argues that a merger clause in the December 1980 agreement bars Appley's assertion of an action for fraud. However, the so-called merger clause merely provides the agreement as the entire agreement of the parties regarding the settlement of this lawsuit. It does not purport to merge any prior representations. So it's true. They said it's not really a full-fledged merger clause, but the next sentence is important. And it shows that merger clauses don't matter, because it says, furthermore, Appley's have not relied on any representations extrinsic to the contract. Their claim of fraud is based on alleged misrepresentations by appellant in the contract itself. Let's go. Yeah, sorry, go back. Appley's have not relied on representations extrinsic to the contract. Their claim of fraud is based on the alleged misrepresentations. And the court also determined that the fraud alleged was that appellant made the representations in that contract, which he knew to be false because he had no intention of honoring the promises he was making therein. And that is exactly what we have here. A present intent not to perform
But what's the representation in the contract?
that he would pay when he never intended to.
And so council referred to that as a promise of performance. It's a promise. Is that a distinction?
And as the Bradley case points out, a promise as to a future event cannot give rise to a claim of fraud except when there is a present intent not to perform. Both architectural, authentic architectural case and the Bradley case both say the exact same thing. When there is a present intent not to perform, it doesn't matter that it's a future promise because you made it knowing you weren't going to do it. So the fraud is now. And as they said in Gaines, the release doesn't apply. Why? Because the release was contained in the document. The fraud is in the document. It occurs immediately after the signing by making the representation that he will perform. And the court's comment about merger clause here is extremely, I mean, it's binding on us here today because it says the merger clause would only be relevant if he were alleging fraudulent inducement leading him into this, but it isn't. It's fraud in the contract itself by virtue of the fact that he never intended to perform. And then let's go on.
Do you have a slide in here that just where you address Brock? That seems to be the strongest case on the McMurdy side.
I do not, Your Honor, because we got it last night, but I'm prepared to talk about it.
You can.
And the key thing is exactly what Your Honor found in Brock. It says defendants sought a directed verdict on Brock's fraud claim, alleging it was barred by the merger clause, et cetera. First, he presented no evidence of fraud. Actionable fraud does not result from a mere failure to perform promises made. Otherwise, any breach of contract would amount to fraud. Fraud does occur, however, when a party enters into a contract with no present intention of performing his promises. But Brock points to no evidence in the record that King did not intend to perform his obligations under the contract when he signed it on behalf of Five Kings. So counsel needed to study that case before he relied on it. It actually shows exactly what we're talking about, that a present intent not to perform can constitute fraud. But here they just failed to show any evidence of it. Well, sure, they're going to lose on that. But nowhere did the court say you lose as a matter of law. They said, point to some evidence in the record, man. And he couldn't do it. And it was a bitter case. And but they had no evidence of fraud. But in Gaines, there was evidence of fraud that he never intended. And in BTL, this is another important case, Your Honor. In BTL, and this is not in our brief, and this is a 278 Appeals Reporter 256 in 2006. They found that there was evidence of 3 separate false misrepresentations contained within the agreement at issue, and found additional evidence creating an inference that 2 of these misrepresentations were made with a present intent not to perform or knowledge that the performance would not take place. And the court found valid claims of fraud, reversing summary judgment in favor of the defendants, even in light of a merger clause. So there was a merger clause in BTL, and the court said there is a present intent not to perform. And so that's fraud in the contract. So merger clause doesn't matter because they're not relying on pre-contractual promises. They relied on your promise in the contract, which was fraud. And then how do we find evidence of present intent not to perform? Well, we can look back to Gaines versus Crompton and Knowles. And in Gaines, the appellant's argument that evidence of pre-contractual evidence shouldn't be admitted because of the merger clause and these other reasons. And the court said, no, that is how you determine fraud. You look at earlier evidence. You look at the evidence, and the same was done in BTL. They said you go back and look at prior evidence. In Minor versus Harrison, the Court of Appeals determined there was sufficient evidence supported a verdict of fraud based on defendant's present intent not to perform because the defendant had been angry with the plaintiff and acknowledged harboring, sorry, not easy for me to say, harboring hostility toward the plaintiff way before the agreement was signed. But that's exactly what we have here. So the argument that, oh, you can't look at 3 weeks before where I threatened to kill you. No, it shows that at the time he got angry, defendant Wood conspired to enter into an agreement that he knew he was going to breach, and he wasn't going to honor it. And the day he had the opportunity, as soon as the money came in, he immediately breached because he never intended. And that's what the emails show. He never intended to honor it. And he had a crazy idea that somehow Rule 1.5E was going to justify it. But as the court has seen, that absolutely doesn't apply. We can even go back to 1993 with the Rooker case. And this is another case where they're talking about fraud in a breach of contract claim. And they said in civil cases, they talked about criminal cases, and they said, you know, it's a tight standard in criminal cases. And then they said in civil cases, however, such evidence, meaning the general character of the parties and their conduct in other transactions, is always admissible when the nature of the action involves the general character of the party or goes directly to affect it. And that was the case involving a claim of fraud. And they said this is always relevant. And it was anger between the two parties, including the party that later defrauded. We have alleged that the defendants never intended to perform their promise to pay plaintiffs. They agreed upon some and always intended to build this odd defense of Rule 1.5 into the agreement, as evidenced by the emails. We have alleged the claims with particularity, and I'm not going to go through all these. I'll just read the first three. Committed fraud because they never intended to pay the majority of the money. Was premeditated, never intended to make the payment required by the settlement agreement. Bad faith in entering into the contract, which they never intended to perform. And then the fourth one is important. Claims of fraud are based on defendants' bad faith in drafting language into the settlement agreement, which was designed to induce the plaintiffs to enter the agreement, which defendant Wood intended at the time of signing to use as a bad faith basis for reneging on performance. He had this whole thing where he was going to say they were completely dissociated from him. And so we said, no, in the preamble, we're not going to agree to that. Well, sort of loosely associated, no. So finally, we settled on lawyers of L. Lynn Wood PC, because that is true. That's what made it into the settlement agreement. But it shows his intent all along was to break the agreement based on this Rule 1.5. Otherwise, Your Honor, why would he be fighting over a preamble? Who would care what it says in the preamble? He was going to use that as some type of a means to say, oh, you know, we're not all in the same firm, and poor Nicholas Sandman, he didn't consent. There's also an abundance of evidence that we will produce that the delay was not, in fact, due to anything to do with COVID-19. But was a desire to wait till Nicholas Sandman turned 18, which happened in June or July of 2020. Okay. The other cases that we have cited, can you go back to Yeah, to the outline. Sorry. And these other cases show it is, and I'm not going to go through all of them, but we did in our brief how a merger and release clause in a contract do not bar a claim for fraud when that fraud is found in the contract itself. So the court's kind of building up to it. It says pre-contractual promises aside, if the fraud is in the contract in a present intent not to perform, then it can survive a merger clause and a release. A party's present intent not to perform constitutes fraud within the contract, and then a party's intent not to perform will not be barred by a merger clause. And then finally, how do we show that evidence? All right. Economic loss.
Yeah, we got about 5 more minutes.
So I need to do economic loss, and do I need to do the motion to strike?
I think we can do that on the pleadings. So let's focus on economic loss. That was the only thing where something new I think was brought up.
Okay, great.
On the
Done with that one. Yeah. All right. Economic loss rule. Again, council has tried to create a new rule of law. And again, it's fascinating, but it's not Georgia law. This idea that the misrepresentation exception somehow has to be made by a professional in the scope and duty of that professional's work, that's just simply not true. The D.L. Horton case that we cite, that council cites, that we all talk about, one who supplies information during the course of his business, profession, employment, or in any transaction in which he has a pecuniary interest. That means anybody. That doesn't mean a professional in his or her professional duty. Anybody who's got a pecuniary interest. Lynn had a pecuniary interest in their money because he wanted it in his pocket, not theirs. So I don't know what he's talking about. They have to be a professional. And it says, has the duty of reasonable care and competence to parties who rely on the information in circumstances in which the maker was manifestly aware of the use to which the information was to be put and intended that it to be used. This liability is limited to a foreseeable person or limited class of person for whom the information was intended either directly or indirectly. So the economic loss rule simply does not apply here. It absolutely does not apply. Indeed, the economic loss rule is inapplicable in intentional tort cases. And it says, however, Georgia courts and federal courts in this jurisdiction have repeatedly recognized an exception to the economic loss rule for fraudulent inducement claims, and it cites Holloman. The economic loss rule is inapplicable in the presence of passive concealment or fraud. And it cites yet another case, Manhattan versus MacArthur Electric, 2007, Westlaw 295535, Northern District of Georgia. Holloman is about a guy buying a house. There was no professional involved. Johnson versus 3M Company is a commercial dispute. There's no professional there. In the case I'm talking about now, James versus Terex, which is on the next slide. Thanks. There are no experts here, so I don't know where this idea of expert service came from, but it is simply not found in Georgia. It is anyone who has a pecuniary interest. In fact, Your Honor, if it were true, that entire table of cases I had would all be economic loss rule cases, wouldn't they? None of them are, because they all involve fraud. So when fraud is present, economic loss is out the window. This is a red herring and is specifically barred under Georgia law. I get it. And then we're not doing motions to strike, not dealing with
I think we can do that I can do that on the pleadings. Nothing, I think really specific was brought up to address for the arguments today.
questions. Anything, Your Honor?
Well, I would ask if both for the PowerPoints, not only on the, that's more housekeeping. We can leave that to the end. So no questions for you right
Do
now.
you want?
That's what I was going to get
We're
to.
going to give it to you.
Right.
No problem.
Okay.
Just 1 second, Your Honor. Oh, yeah. And we did allege additional damages in the complaint, which are important to talk about because that would invalidate the economic loss rule as well.
And let's see, you got it pulled up here. What are those? Reliance.
They incurred additional expenses and additional fees that they would not have. And they have conspiracy and tort claims, attorney's fees claims, and a variety of other damages which would invalidate the economic loss rule as found in a host of Georgia cases. Thank you, Your Honor.
All right. Thank you, Mr. Beal. So I think at this point, it's people are motioning that they want more to say.
May I reply, Judge, briefly?
And everyone always says briefly. I'll give you a minute or two, but I'll give everyone a minute or two again.
Yes, sir.
But at some point, we do have to stop talking,
It'll be very brief.
myself included.
If I may approach, Judge?
Sure.
I'm going to give you a letter. This is a letter that Olson and Bird sent to Mr. Beal on August 31st, 2020. It's a notice of abusive litigation. And in that letter, they explained to Mr. Beal that his first filed complaint, a breach of contract complaint, was abusive litigation because even though it inserted a fraudulent inducement claim, which was contrary to law, it was there.
So is this
So-
part of the record?
I will make it part of the record.
Well, I don't think this is an evidentiary hearing. Doesn't it always have to?
Well, it's a letter that we all have, but this is the importance of this letter. The importance is that Mr. Beal said that I'm a liar, that he already claimed present intent in his first amended verified complaint. He did not. He only does it in the most recent complaint. So I just want for the court to know that I'm not a liar. As to his cases, he relies on authentic architectural millworks versus SCM Group. In that case, SCM represented in the contract that no manual lubrication needed throughout the lifetime of the router. That's a fraud in the contract, when the truth is that the router in that purchase and sale contract required daily manual lubrication. So there was a lie, a misrepresentation in the contract, not on an email from February 22. The other case that they relied on is Gaines versus Crumpton and Knowles. In that case, the contract's merger clause merely provided that the agreement was the entire agreement, but it did not merge any prior representations, as the settlement agreement of March 17, 2020 did. They also relied on Bradley versus British Fitting Group. In Bradley, in his deposition, Bradley acknowledged that his counsel had informed him that he could sign the release and later proceed with his claim in the UK, even though the release settled all claims which exist, whether known or unknown, between BFG and Bradley. So when he signed the release that day, he knew that the next day he'd be filing in the UK another claim against that same employer, even though he was saying as he signed that he would not.
Isn't that exactly what they're saying happened?
No, they're saying that the settlement agreement, contains a lie. Where's the lie? They haven't pointed to the lie. They say that the settlement agreement, which it does, requires Mr. Wood to make a payment at some point. If he does not make that payment, that's not fraud. That's a breach of contract. And they're trying to make it a fraud, but they can't because there's no present intent. All they have to rely on is really not the contract. They want the court to believe that, but what they really rely on is the February 22 email, not the contract. Thank you, sir.
All right. Thank you, Mr. Reyes. And
Just
obviously,
real briefly,
well,
one
let
thing.
me
I
let,
just-
let me let Mr. Gillifin go, and then I'll let you finish it up. And I'll obviously be taking a close look at all these cases.
I make one point pro se.
Sure, Mr. Wood.
At the time we signed the agreement, Joy Burby and his firm prepared working with him. The expectation was that.
Objection, Your Honor. I'm going to object to him
Very short.
making this
That we were gonna-
Well,
evidentiary.
Mr. Wood, just let him, Mr. Wood, I'm going to let him make his objection, and then I'll rule on it, and then we'll decide whether we can still hear on this.
As the court noted, this is not an evidentiary hearing. This isn't in evidence. This is a 12B motion. They have to look at the second amended complaint, nothing else.
Okay.
His thoughts.
No, I understand your objection, Mr. Beal. So, Mr. Wood, you started off your response with the expectation was, are you referring to something that's already in the record?
It's in the record that there was going to be a probate approval within days of the agreement being signed. That then got delayed because.
Objection, Your Honor, that's not in the record.
That's not, that's.
Just
I
not
make
in the
that-
record.
I make that point because you suggested that somehow similar to the guy that signs it, the next day intends to sue somewhere else on it. That's not the case at all. We all, in the record, we're expecting it to be approved by the probate court within days, and then COVID delayed it.
Okay. All right. Thank you, Mr. Wood, Mr. Reyes, Mr. Gilfin.
Thank you, Judge. I appreciate it. I will be brief. I will only address the merger clause issue. I want to begin by saying, in listening to counsel's argument, he proves the point. The issue here is not under what circumstances a present intent not to perform a contractual obligation can be a fraud claim. That's not the issue here. Mr. Beal, when he addresses these cases, he repeatedly talks about they address the release. He said, Bradley, he said, it talks about the release. Gaines addresses the release. The issue is the merger clause, not the scope of the release. In Bradley, the court was addressing under what circumstances a present intent not to perform can be fraud. It didn't address the effect of a merger clause like the one here. In Gaines, there are two paragraphs. There's paragraph A and there's paragraph C. Mr. Beal relies on paragraph A, which concerns a release. And he talks about that paragraph. The paragraph that supports the argument I'm making is in the Gaines case. It's paragraph C. And it says, Mr. Beal agreed, he acknowledged. The court said the merger agreement there is different than the merger agreement here. He said it's not a full-fledged merger clause. Okay, that case doesn't apply to this one. And then two final points. Mr. Beal brought up BTL-COM, which I didn't address. He didn't cite it in opposition to our brief. However, in BTL-COM, the court addressed three alleged misrepresentations or three misrepresentations. One was a factual misrepresentation on the face of the contract, which is exactly what we say is required to avoid the effect of a merger clause. Not surprisingly, the court found because of that, the plaintiff could proceed. Then there were two other claims of present intent not to perform. And having dealt with the factual misrepresentation that gets you out of the merger clause, the court went on to address this other unrelated issue of in what circumstance could a present intent not to perform be a fraud claim, which is not the issue here. And then finally, Brock. The fact of the matter is, Brock has two separate holdings. One goes exactly to and rejects the argument that the plaintiffs make here. Thank you, Judge.
All right, Mr. Beal.
Thank you, Your Honor. First of all, I wasn't calling counsel a liar. I was disagreeing with what's in the first and what's in the second amended complaint. So just want to be clear about that. It's important to note that all these cases that we're talking about on fraud, they are not motion to dismiss cases. They're motion for summary judgment cases. And clearly, the plaintiffs have the right to the discovery to prove their claims. Not a one of them is dealing with a motion to dismiss. Secondly, counsel talks a lot about, well, these are release cases. Gaines is a release case, not a merger clause case. But as Your Honor knows, a release is even broader than a merger clause. Merger says all your private prior conversations are merged into this one. But if we look at what the Gaines court says, it doesn't matter if there had been a valid merger, because you're not relying on representations extrinsic to the contract. You're relying on the fraud in the contract, which wouldn't be barred by a merger. And that's why our 4 or 5 cases, Authentic Architectural and the other 4 cases, all deal with merger clauses failing in a when the fraud is within the contract. So it is essential to look at what the Georgia Court of Appeals says in Gaines. And in BTL, the court does indeed say there are 3 separate allegations of fraud. But the key thing is it says 2 of them are fraud at the present intent not to perform fraud. And that's what defeats the merger clause. Lastly, Brock, they just can't get away from the fact that in the Brock case, there is no evidence of fraud. And that's why the court ruled the way they did. The Brock case is not controlling to us here, because if we don't have any evidence of fraud, well, of course they're going to win. But in that case, the court based its ruling on, first, he presented no evidence of fraud. Then he goes on to say that Brock didn't rescind the contract, so he's looking only at the contract. He would be limited to showing fraud in the contract, and he can't do it. He can't point to any evidence in the record. Thank you, Your Honor.
All right, we'll leave it at that. So obviously there is a lot to digest and a lot of homework to be done. We'll be taking a look at all of these cases. We'll be taking it under advisement. We'll be in touch on these issues. A few housekeeping matters. Any PowerPoints, you can send them to us in their entirety, whatever you'd plan to or did show. And if you could just email that to Staff Attorney Ms. Sue. I do feel like we can still power through here and at least I wanted to give Mr. Wood and plaintiffs an opportunity to be heard, just because it was filed in advance of the contempt hearing last month. There was a motion to lift the injunction. I don't think there's too much to be said, but I did want to give you the chance to be heard on it if you're prepared on it. I know that may not have been on the calendar of events, but since we're all here together, was
The injunction.
you'd filed a motion in advance of the contempt hearing to lift the injunction.
I apologize, Your Honor. I'm not really prepared to discuss. I don't even have our brief with us. I didn't know.
That's fine.
this was on the
That's fine. Was
calendar.
that Mr. Reyes?
My position is that as well.
Okay, that's fine. We can put that off for another day. I was just trying to address as much on the docket as we could today. So where I think that leaves us, then we'll move on from that. I think regardless of how the rulings come out, there would still be a breach of contract claim against Mr. Wood. So I think we could at least preliminarily start talking about discovery and the time frame of that, so we can get the case moving along. I think the idea would be, as we've been doing in our other civil cases, imposing a case scheduling order. Our standard time frame we've put in was 6 months for discovery. However, due to the length of this case, and maybe because there's already been some pre-motions discovery, maybe you don't need that long. Maybe there aren't that many witnesses to depose. Maybe because the case has been going on so long, we want to speed things up. You tell me. But the idea would be 6 months with a deadline for dispositive motions, a deadline for experts. And if we stick to that 6 month timeline, I could conceivably see us starting to get on trial calendars in early 24. But let me hear from y'all on that. I'll start with Mr. Reyes and Mr. Wood. Yes, sir.
I need to make it in the record clear. I didn't have a chance to file a formal withdrawal as counsel, but I will be doing that in the next couple of days. And my appearance is one of pro se. I'm retired from the bar. I'm allowed to represent myself pro se, and I want the court to know that. As far as the question about discovery, I think the 6-month rule that you normally apply would be best here, because there's a lot to be done. It may not be as much if it's narrowed down to where it should be, that is the breach of contract.
Well, I would also say, again, since we're all here together, let's operate under both worlds and say hypothetically, if the fraud claim does go forward, is 6 months still going to be sufficient in your opinion?
Yes.
Okay. And
Us as well, Your Honor.
all right.
We have had some problems with counsels not responding to discovery, partly because he says, oh, well, that relates to the fraud claim and that's all going to be thrown out. And partly because they just haven't responded. So,
Well, that leads me to my next point, which was going to be, so the idea is when we are able to get a ruling together and issue some decisions and orders on all the motions we discussed today, we put the case scheduling order in at the same time and just due to the nature of this case and what I've been able to learn about it as it's been going on. I think at the slightest hint of contempt motions and discovery violations from either side, I think this is going to have to be a special master case, just because of the amount of time that goes into all of these. We're still having to dig out of our criminal background backlog. We've got it whittled down to 43 different murder cases. So we'll schedule one a week and we'll still be behind where we are at this point. So the fact is for every single discovery dispute that comes up along the way, to bring everyone back here and have a full day, I just don't think it's something that's going to be feasible. So just a word there is that I do think that the court has the authority just sua sponte to impose a special master with the fees to be split. And I can very well see us doing that to address any and all discovery disputes that come up during that 6 months.
for the plaintiff, we're fine with that, Your Honor, if we limit it to the discovery disputes and we can jump in and we can dump all of our motions in together. And they're all kind of the same thing, haven't responded. And so they can blow through those pretty quickly. And if they get answered, then that would be a huge clump of the discovery already done. And as the court pointed out, there aren't many witnesses in this case. There's our side, their side, and the other defendant, and a handful of other witnesses, but it's all pretty limited. It's all directly, and they were all very verbose. So they wrote everything down and sent it to each other. So we kind of have it if they just turn over the rest of the documents. So it's pretty straightforward.
Mr. Wood, anything you want to add based on kind of my thoughts that I've laid out there?
Your Honor, I would urge the court to maintain the case and not appoint a special master. The issues in discovery, I think, can be resolved in short order. It doesn't require hearing after hearing, because the practical situation is, Judge, I can't afford it. So I'm going to be at a great disadvantage if you appoint a special master. I've been in litigation for 40+ years. I haven't been able to practice law in over 3 years. I don't have a lot of money. So that's the situation. And I think I'm entitled as a citizen to have this litigated before court without having to pay a special master. That's all I want to say.
Well, you know, the greater expense of a special master really comes down to how the parties conduct themselves, right? And so if there are any disputes, the special master isn't going to have anything to do. But certainly that's something that I would keep in mind. And in terms of the burden that places on you, if that's something you want, I think it might even be your burden to actually plead that and show that, and not just, you know, I think maybe that would have to be something that's under seal or in camera. But to me, just the statement of, well, I can't pay the fees, not knowing what the fees may be or how extensive they are, I think I'm going to need a little more than that.
I'll be happy to give it to you. The problem is I've dealt with special masters before, and they are very expensive. And I wouldn't have to be the one generating cost. They could be doing it. So it just puts me at peril. I have property in South Carolina. I have people employed there. I have a responsibility to them. And when you suck down the money out of all this litigation, that's why I've tried to move it along. And I got stuck here because of the different judges. And I was pleased when you said last time that you were going to take the case and you were going to run it and get it done. That's what I need to have. From my standpoint, I would think they would want that too, to get it done. And if we get into a total re-review of all of the morass material by a special master, just getting familiar with the case, would take him a lot of time and a lot of money, which I think is unnecessary.
Well, I guess one thought that comes to mind is, and we've done it in another case, is that if there's a discovery dispute that a special master has to rule on and it was completely meritless, and you can file a motion to say the other side should have to pay all of the fees related to this particular dispute. That's a way to allocate and shift the financial burden. And again, I think the idea would be if we're in the middle of a deposition and a dispute comes up, that's where the special master can step in. If we're talking about interrogatories and just those kind of the standard civil things that can really bog a case down. It seems like that wouldn't be too extensive, but we can see where that goes.
But we'll say this. If Your Honor agrees that the fraud claim is to be dismissed, then the breach of contract. I'd be happy for Your Honor to order the breach of contract case to be sent to binding arbitration before 3 lawyers that can make a ruling on this consent issue and be done with it. I offered that before this whole lawsuit started.
Well, I don't think that's anything that the court kind of steps in and handles. I think that's more of a settlement negotiation for you to take up.
You could order you could order mediation.
I'm certainly, I think that already happened, didn't it? Isn't that already in the record? It didn't?
There was no offer of settlement, zero. And there was a statement that I'm never going to offer you anything. So that didn't go very well.
Well, he's talking about before March.
Okay. So wait, let me explore this. Are you saying both parties are amenable to me ordering mediation?
I'd be happy to have mediation on the breach of contract. I'm not interested in mediating over this fraud claim, which I think should be dismissed and should have never been brought up.
Okay. Well, let us sort through that. And maybe that'll be the plan. I think, again, this is another of those where regardless of the ruling, perhaps we also, along with the scheduling order, put in a very early mediation requirement.
Your Honor, going back to the discovery disputes, all of our motions have a common theme, haven't answered, haven't responded. So they're all kind of the same thing. I think if you want, we'll pile them all up together and create a roadmap, and Your Honor could rule just on the paper because we just want answers to stuff, and there were no answers. And in a couple of them, the answers were months and months late and still asserted crazy objections. So it's not going to be a big in-depth. In our other case, they took depositions of our clients. There were no disputes.
You're addressing the special master issue and disputes.
And in the other case, we went through hours and hours, days of depositions, and there were no disputes at all. The clients got a little angry with each other, but there were no evidentiary disputes. We didn't have to call the judge in the federal court case. We went through one whole day of Mr. Wood and 2 or 3 days of the plaintiffs, and there was not a dispute about, well, can you answer this question? Can you not? Does this document come into evidence? There were none of those. So that was 4 whole days. And they're the key players. So I don't know that there's going to be a lot of disputes. We can just get a ruling that the stuff has to be answered. The objections have been waived. Give us your stuff and we can move on. I think it'll move pretty quickly.
Okay.
Judge, I don't know what he's talking about. I thought we'd answered everything.
We have.
Okay. Well, I'll let y'all take that up, and then maybe that could be something that, again, we can audit, see what's outstanding. And maybe that would be the initial, if there's still something that you say is outstanding, maybe that's the initial referral for the special master to get into.
Or if we miss something, we can answer.
Exactly right.
We answered everything.
Well, and communication is key. So I think we've probably covered everything we can today.
Lastly, Your Honor, we
Okay, never mind.
filed a second motion for contempt.
Yes, you did. All right.
Everything.
Sure. So I think that was Wednesday. So I've received it. I'll be looking at it very closely. And taking that under advisement. I've not yet planned on scheduling that in the near future. I will say, though, that plaintiffs at any point going forward are welcome to continue amending it if it's appropriate.
Thank you, Your Honor. I don't know that we need an oral argument on it. It's all pretty plain what's in there.
Well, I think any finding of contempt requires notice and a right to be heard.
Right,
So we would have to have another hearing.
right.
All right. So at this point, I think that's where we leave that. Okay. We'll see you next time.
Thank you, Your
Court's
Honor.
adjourned.
What about the motion to strike? What are we doing? It's gonna do it ourselves.
Say, did a great job. I wouldn't call you a liar. I really wasn't. I was just saying you're wrong. Big difference. But I wasn't. Whatever.
wrong.
But I didn't want
You
you to
didn't claim
think,
present intent.
I didn't want you to think I was saying, no, he's lying about something. I wasn't. I think it's important to draw
No
a
problem.
distinction. Cool, man.
Mr. Reyes, look at paragraph 201.
Not on the first.
Oh, it is, it's there. I'll find it.
It's all right, it's all right, it's all right, it's all right. It's not on.
No, you asked me, can you object?
Oh, yeah.
So I want to tell you, as a teacher,
Yeah.
there's a few instances where we